Sure, we can. Just give me 1 second. Good morning. I would like to call the Monday, April 3rd Board of Zoning Adjustments meeting to order. We will begin with roll call. Candace Forrest is absent. Todd James,
Present.
Tamira Eggins,
Present.
Jose Alvarez,
Present.
Jamie Ramiro Diaz,
Present.
Alfonso Gonzalez,
Present.
Matt Rufo.
He stepped away.
Okay. At this time, would the board make a motion to adopt the minutes from the March 6th meeting?
So moved.
Second. All right, we have a motion and a second on the floor to adopt the minutes from last month's meeting. Tomorrow was the motion. All right, go ahead and vote your machines. And that motion passed.
As a reminder to applicants, action that the board takes today will be released in the form of a disposition notice by April 13th and sent via email and mail to the applicant, as well as posted on the One Stop app for other interested parties. Requests that the board votes to approve must show compliance with any noted provisos before the case is finalized and granted final approval. We will begin with unfinished business for variances. Would the vice chair please read the hearing rules for variances?
Thank you. The following procedure shall be observed during the hearing. Each speaker shall give their name and address prior to speaking on the proposal. The applicant or representative will speak first. The presentation shall be limited to a maximum of 3 minutes for each applicant or representative speaker, but in no event shall the cumulative presentation totaled by the applicant or their representative exceed 10 minutes. Proponents or persons in favor of the proposal will speak next and be allowed 2 minutes per speaker. Opponents or persons in opposition to the proposal will speak next and be allowed 2 minutes per speaker as well. And the applicant or representative will be allowed to rebut. The rebuttal will be limited to a cumulative maximum of 3 minutes. Additional information. For an exceptional case, the time limitations may be extended by the presiding officer with the approval of the board. As the board deems necessary, the case may be acted upon in this meeting or deferred for additional information or review. If the case is deferred, it will be acted on at a subsequent meeting as provided by law. All proper parliamentary procedures shall be followed, including recognition of speakers, relevance of argument, and absolute prohibition of applause or demonstration. Our standards of review. The Board of Zoning Adjustments shall not authorize a variance for requirements of the comprehensive zoning ordinance unless it finds, based on the evidence presented to it, that each case has satisfied the 9 criteria listed in Article 4, Section 4.6F of the comprehensive zoning ordinance.
Thank you. The first item on the agenda is BZA 00323 for the property at 1124 Louisiana Avenue.
The next BZA 00323 is located at 1124 Louisiana Avenue. This request is for a variance from the provisions of Article 21, Section 21.6.n.1.a of the Comprehensive Zoning Ordinance to permit the retention of a fence with excessive height after the fact. In accordance with Article 21, Section 21.6N1A, the permitted maximum fence height in the HURD2 Historic Urban Two-Family Residential District is 7 feet. The applicant is seeking a variance to retain a fence with an excessive height of 9 feet, 7.5 inches. It was recently brought to staff's attention that the use of the subject site is a multifamily dwelling rather than a single-family dwelling, as was indicated in the permitting database. Because multifamily uses must complete the Neighborhood Participation Program, NPP, and because the applicant has not done so, staff recommend a 30-day deferral of the requested variance to allow the applicant time to comply with the NPP requirement.
Is the applicant present for BZA docket number 003-23? Anyone here to speak in support of this request? Anyone here in opposition? Okay, I'm assuming that had already been coordinated with the applicant, so they're aware of the deferral.
Correct. They are
Thank you.
aware of the NPP requirement.
Thank you. What's the pleasure of the board?
If there's you're ready for a motion, I'm ready to give one. In regards to BZA 003-23, I move for a 30-day deferral following the staff's recommendation.
Okay, we have a motion on.
Second.
We have a motion on the floor by Commissioner Gonzalez and a second by Commissioner Alvarez. To defer the docket item for 30 days at the request of staff. Please vote your machines. All right, that motion is passed. Next item.
BZA 004-23, located at 7808 Pearl Street, is a request for variances from the provisions of Article 11, Section 11.3.8.1, Article 11, Section 11.3.8.2, Article 21, Section 21.6.H.4, and Article 21, Section 21.7 of the Comprehensive Zoning Ordinance to permit the construction of a single-family residence with insufficient front yard setback, insufficient front yard build-to line, insufficient rear setback, excessive carport height, and a carport that encroaches into the required front yard. There was a meeting held between the applicant and a BZA administrator in which the applicant requested a 30-day deferral in order to create new plans that will comply with the CZO.
Is the applicant present for BZA docket number 004-23? Anyone here to speak in support of the request? Opposition? Okay, hearing none. Any questions from the board?
Vice Chair, if a motion's in order.
Believe so.
In regards to BZA docket 004-23, I move for a 30-day deferral following the staff's recommendation.
Okay, we have a motion on the floor.
Second.
All right, we have a motion on the floor by Commissioner Gonzalez and a second by Commissioner Alvarez to accept the staff's recommendation for a 30-day deferral for BZA docket number 004-23. Please vote your machines. And that motion passed. Next item.
The next item is BZA 015-23 for the property at 2811 through 2813 Powhatan Street. This request is for variances from the provisions of Article 13, Section 13.3.8.1, Table 13-2, Article 21, Section 21.4.A, Table 21-1, and Article 22, Section 22.4.A, Table 22-1 of the Comprehensive Zoning Ordinance to permit the construction of a second principal structure resulting in insufficient rear yard setback, more than one principal building on a lot, and insufficient off-street parking. At its March 6th meeting, the board requested that the applicant explore options to develop the property with a two-family dwelling in which it is permitted by right rather than a second principal structure on the lot. The board deferred this request 30 days at its April 30 days to its April 3rd meeting. The applicant contacted staff on March 15th questioning the impact of developing a two-family structure. The staff informed the applicant that the provisions of Article 25, Section 25(4)D, additions and enlargements. The applicant contacted staff again on March 21st via email to point out that the property located next door to the subject site, 2805 Powhatan Street, is developed with a second principal structure. Photos provided by the applicant are depicted in figures 8 through 10. As noted previously in the report, the staff indicates that there are a few examples of dilapidated structures located at the rear of some lots, according to Article 25, Section 25.3.c.1. However, so those are the non-conforming structures. I didn't write out the whole thing there. However, after a non-conforming use is deemed abandoned, vacant, or unoccupied for 180 consecutive days, the non-conforming use may not be reestablished or resumed. Staff requested that the applicant provide a photo of the meter of the property. This evidence was not provided. According to the Orleans Parish Tax Assessor's website, 2805 Powhatan Street is developed with a single family dwelling and a garage, as indicated in Figure 11. While the staff was unable to confirm whether or not 2805 Powhatan Street is developed with a second principal structure, evidence of such a condition would not change the staff's recommendation, as one example of two principal structures on a lot does not demonstrate a right commonly enjoyed by other properties in the district. Further, the staff has not received a revised proposal, thus the staff's recommendation remains the same.
Is the applicant present for BZA docket number 015-23?
Good morning. Good morning, Patrice Poirier, 28, 11, and 13 Powhatan Street. To
Yeah.
follow up with what Ms. Goins has mentioned, we did go back and look at combining the two structures. There was some information given to me by the architect and engineer that I would lose a lot of the square footage if I was to combine it. I sent that information back to Ms. Goins for verification. She did verify some of the information was accurate in that. So that was my only concern, was that rebuilding the structure, I would lose a substantial amount of square footage if we were to attach the two buildings.
Okay, does that conclude your comment?
This is not the correct property that's on the screen.
I'm sorry. That's much going on.
We do have the packets of.
Oh, okay, I'm sorry. So as you see, I've begun construction on the front structure. It was my intent to renovate both structures, but once we took out 10 trees, we realized there was nothing salvageable in that second structure. So that's what the reason why I have to come before you guys to get an approval to rebuild that second structure, because it is in very poor condition at this point. I also want to point out that the rebuilding the second structure would be up to current code, and it would be a smaller footprint than what was previously there. The structure that was there had been there since 1950. It was last occupied, to my knowledge, for Hurricane Katrina, because I purchased it via Civic Stores. And once we were able to get into the property, it was like a time capsule. It was everything that the residents left from Katrina. So with cleaning out the property and getting all those trees removed, we found out that there was nothing that was salvageable. So I'm asking the board to allow me to rebuild a smaller separate structure in the rear of the main structure as the property was originally designed.
Okay, does that conclude your comments?
Yes.
Okay, thank you. Anyone else here to speak in support of BZA docket number 015-23? Anyone here to speak in opposition? Okay, hearing none, is there any questions from the board? And maybe just to get either clarification from staff or from the applicant, when the description was provided that you would lose square footage, if you could provide clarity to that piece, I'm not following that part.
So I believe what she's referring to is when you expand a structure, and there's like you can't expand on a nonconformity. So there is a slight nonconformity on that lot, on the side yard setback. I think it's like about 2 and maybe 2. I can't, let's see. Let me take a look. It's less than 3 feet though on the side yard setback. And if they were to expand on that nonconformity, they would have to bring the rest of the property into compliance, I believe. Is that correct?
If they're expanding because they're adding an additional dwelling unit, they don't have the right to expand along the non-conforming side lot line. So they would have to ensure that that portion is compliant.
Okay, so if they would expand off the rear footprint of the building in order to get the second compliant unit, they would have to bring the existing structure into compliance or just the addition?
Just the addition.
It should just be the addition.
And what was the proposed square footage of the non-conforming structure versus what would be allowed to be built? Because if I understand correctly, they will be able to expand on the footprint within the allowable buildable area towards the rear yard, but not into the rear yard.
They would be able to expand into the rear yard, but not into the required rear yard. if
Correct.
That makes sense.
Yeah, that's
Okay.
we're saying it the same thing, two different ways.
Okay, yeah.
So I'm just not following how,
Yeah, and I was just gonna say, so if the side yard is 3 feet on either side required. And what's the rear yard setback? 20 feet,
20
15
feet.
feet?
and you could also build up.
Actually,
So I'm
yeah,
not
so
really.
you might end up with actually a larger structure than what's there
Right.
in the back now.
I'm not sure what, I know you said that your professional record gave you that response. I mean, I think they may be speaking purely within ground floor coverage of what you could build within. But based off of that, I mean, you still have the allowable, you're still allowed to build up. You're still allowed to build maximize to at least to the rear yard setback as well as the 2 side yard setbacks, which to me, if you're reducing the footprint of the structure smaller than what was the existing non-conforming structure in the rear yard, you have the ability to build more square footage of an attached compliant structure.
What he told me was that they needed to take 50% of the main structure. So say, for instance, if the main structure was 1,000 square feet, the second or the addition that we were proposing to connect would only be a maximum of 500 square feet. So I'm not an expert in that area. So I don't know, but this is what I was told.
Yeah, just at first glance, just even looking at your plat plan versus knowing what you're allowed to build, even within a vertical envelope, you can go well beyond 500 square feet, and that's just at glance.
Okay.
I mean, unless they're trying to look at it purely from 50% of square footage, but that rule doesn't apply in this case. And look, staff, jump in on this one, please, before I go too deep into the advice role. But you're seeing it's just at first glance, understanding what's been spelled out in your first request, which is probably the bigger requirement, less than what you're looking for with the second variance request for the off-street parking.
So you're stating the connecting, if we were to connect the building, it would be similar to the square footage of what we were proposing for 2 separate structures.
If not more.
Yes, I wasn't given that information from the architect. But essentially, it would still be a multi-family.
You can
Or the-
still
or
have
the-
2 units. I mean,
Right.
we're not reducing that fact. The problem is the second unit is a separate principal structures, whether the hangup occurs and with it being within the required rear yard. So, but you still being able to have a double residence at this point is still an option,
Okay.
and that's what staff is also calling.
Well, I'll move forward with that and
Okay.
I'll consult another architect or engineer to do it the way that you all are proposing.
I would tell you, talk to, not knocking, but
Right.
talk to an architect to understand this a little bit better.
Right.
Anybody else have any questions?
I was gonna say, instead of, since she's gonna go back to the drawing board, maybe you'd be comfortable with the deferral to. Well, I don't know, or you just would, okay, then shut up.
I mean, look,
Well, the staff does recommend approval of the off-street parking
correct.
requirement, so.
So I mean,
just the two
you could
principals.
proceed with what's recommended is one option, which would allow for you to get the off-street parking waived.
Okay,
But the second principal structure would go away, but then there would be a prohibition of 2 years on that request for it to come back. Or if you deferred it, and let's say you did 60-day deferral, to be quite honest, in order for you to really vet the timing of what's needed for your plans. That would probably be that's just another scenario for you that doesn't kick anything out, that if you did need to come back and let's say all of our dialogue is completely wrong. That at least gives you the ability to still come back in front of the board to ask for the request that you have right now. So it's if you want to stay on the course of adding on to it, we could follow the recommendation or go.
yes, I'll go ahead and take the recommendation to add on.
Okay. So you want us to go ahead and approve the off-street parking?
Well, no,
Hold
because
on that.
I'm
I
gonna
can't say
lose,
approve it.
I'm sorry.
I can't speak and say that we're gonna approve it. You have the option of us reviewing one, which would be to approve what the staff has in front of us, or deferral, which would give you more time.
But just for clarification, so what you're proposing is to approve off-street parking only. And I would lose the right to,
To put the second
put the
principal
second
structure for
structure
at
in.
least 2 years.
okay, well, no, so I'll take the deferral then and have the plans redone and resubmit it back to you guys and come back.
Okay.
She could also choose to withdraw that.
Yeah,
Yeah.
yeah, she could withdraw at a later date, but I think that still exempts the. All right, so what's the pleasure of the board?
Happy to make the motion. In regards to docket 1523, I move to defer for 60 days. That's not like a
Second.
question. Second, 60 days.
All right, we have a motion on the floor for 60-day deferral. Do we have a second?
Second.
Okay, we have a motion on the floor by Commissioner Diaz and a second by Commissioner Eggins for a 60-day deferral to provide the applicant more time to look at an alternative form of compliance. Please vote your screens. And that motion is passed. Next item.
The next item is BZA docket 01723 for a property located at 1519 Barone Street in the HUMU zoning district. This request is for a variance from the provisions of Article 12, Section 12.3.8.1, Table 2.2 of the Comprehensive Zoning Ordinance to permit the conversion of a two-family residence to a single-family residence resulting in insufficient rear yard setback. The applicant is proposing to provide 9.75 feet and is requesting a waiver of 5.25 feet. Based on the analysis, staff finds that the requested variance of rear yard setback fails to meet criteria 1, 6, and 7 of the standards for variance, and the staff recommends denial. Staff received a communication from the property owner Friday requesting deferral to the May 1st BZA meeting in order for either the property owner or the architect to attend the meeting.
Is the applicant or representative present for BZA docket number 017-23? Anyone here to speak in support of this request? Anyone here to speak in opposition? Seeing none, any questions from the board?
Motion's in order.
Okay, you proceed.
In regards to BZA docket 015-23, I move for a 30-day deferral per staff's recommendation.
Second.
Well, 15 or 17? 17,
What's
just
that?
to clarify that motion.
17, my apologies.
No problem. In a second. All right. All right, we have a motion by Commissioner Gonzalez and a second by Commissioner Rufo to accept the staff's recommendation for, it was a 30-day deferral to give the applicant time for a representative to be present. Please vote your screens. And that motion is passed. Next item.
Thank you. We will now begin with unfinished business for safety and permits decision appeals. Will the vice chair please read the hearing rules for decision appeals?
Right, sorry about that. We'll go over the rules and procedures for appeals of the decisions of the Director of Department of Safety and Permits. The following procedures shall be observed during the appeal hearing. Each speaker shall give their name and address prior to speaking on the proposal. The representative of the Department of Safety and Permits shall present to the board the decision which is under appeal, the relevant code sections related to the appeal, and any information explained in the department's decision. The applicant or representative will speak next. The representative shall be limited to a maximum of 5 minutes for each applicant or representative speaker, but in no event shall the cumulative presentation be by the applicant or their representatives exceed 15 minutes. Proponents or persons in favor of this proposal will speak next and be allowed 3 minutes per speaker. Opponents or persons in opposition of the proposal will speak next and will be allowed 3 minutes per speaker as well. The applicant or representative will be allowed a rebuttal. The rebuttal shall be limited to a cumulative maximum of 5 minutes. Additional information. For an exceptional case, the time limitations may be extended by the presiding officer with an approval of the board. As the board deems necessary, the case may be acted upon at this meeting or deferred for additional information or review. If the case is deferred, it will be acted upon at a subsequent meeting as provided by law. All proper parliamentary procedures shall be followed, including recognition of speakers, relevance of argument, absolute prohibition of applause or demonstration. The standards for review. The Board of Zoning Adjustments has the power to hear and decide appeals where it is alleged that there's an error in any order, requirement, decision, or determination made by an administrative officer in the enforcement of the comprehensive zoning ordinance. The board also has the power to hear and determine appeals from applicants who have been refused a building permit because of a violation or conflict with the zoning ordinance or the official map of the city. The applicant's appeal to the Board of Zoning Adjustments is governed by Section 5-408 of the City of New Orleans Home Rule Charter.
All right, good morning, everyone. My name is Nick Kindle. I'm the zoning administrator in the Department of Safety and Permits. So this is BZA docket 13-23. Relative to 712 Washington Avenue, the applicant's appeal alleges an error in the decision of the director of the Department of Safety and Permits regarding the reissuance of permit number 22-033387 RNVS. The subject property, 712 Washington Avenue, is an existing two-family structure that's being renovated into a 4-unit multifamily dwelling under the small, affordable multifamily dwelling provisions in the CZO. The permit was first issued on April 5th, 2022. However, that permit was rescinded after it was discovered that the scope of the permit did not include the previously unpermitted addition to the rear of the structure by the former owner. The current owner provided additional information to confirm compliance with the building code and CZO, specifically the rear yard setback and permeable open space requirements, and the permit was reissued on November 14th, 2022. The reissuance of permit 22-033387 RNVS is the subject of the appeal. The appellant raises a number of issues which are addressed individually. First, based on the owner's proposed plans, the new permeable open space is only 29.25%, which does not meet the 30% requirement. The zoning division staff calculated the permeable open space based on the plans that were submitted by the applicant and calculated a permeable open space of 1,302 square feet or 35.2% based on the lot area of 3,691 square feet. This complies with a minimum requirement of 30%. The second issue does not meet SFM 101-7213 and IBC 1010.1.5 through 1010.1.7. Provide legal landings outside exterior doors that are within ½ inch of an interior finished floor elevation. The state fire marshal's life safety code and international building code requirements do not relate to the comprehensive zoning ordinance and are not under the jurisdiction of the Board of Zoning Adjustments. The third issue, conversion from 2-unit to 4-unit, remove parking spaces on the first floor and now has 0 parking spaces. With 8 bedrooms, this could incur up to 16 vehicles without parking. There does not appear to have been any legal off-street parking spaces at this location. Furthermore, a small multifamily affordable dwelling is not required to provide any off-street parking spaces, so this development is not required to provide any off-street parking. Issue number 4. Previous plans stated ADA accessibility, current plans say FHA accessibility. There are no notes or drawings for a ramp for the newly raised foundation that has a step up from the entrance. No ramp would even be feasible because the step up is within the unit after the swing from the door. ADA and FHA accessibility is not a comprehensive zoning ordinance requirement, so this is not under the jurisdiction of the Board of Zoning Adjustments. Issue 6. Owner has disregarded HDLC guidelines related to replacing wood with wood and instead has used hardy. Pertains to fascia at the front second floor overhang. Owner is not following his own drawings related to the fascia on the sides of the house and instead installed lap siding all the way up to drip edge. Owner has made changes to stucco facade without HDLC approval. HDLC design guidelines are under the jurisdiction of the HDLC, so this is not something that's appealable to the Board of Zoning Adjustments. The next issue, multiple cost estimates still do not reflect actual costs. By underpricing and omitting major items, which has reduced the permit costs, windows costs $48K, permit costs $15K, just one example of many. The overall construction costs and contract value is not regulated by the CZO, so this is not under the jurisdiction of the Board of Zoning Adjustments. The next issue, specific roof construction set for the rear balcony does not even show the second floor column, ceiling, or structure of the roof. The plan indicates that the rear balcony will be modified to comply with the 15 feet rear yard setback. Based on those plans, the balcony will comply with the CZO requirements. The next issue, owner believes that he can market 2 parking spaces in previous driveway, which illegally blocks the sidewalk and right of way. There's not one legal parking space for this property. The plans show that the area in front of the structure will be permeable gravel. There is no indication from the plan set that this area will be used as off-street parking. Off-street parking is prohibited in the front facade of the structure, so this is not permitted in this location. If the area is used as off-street parking, that would be a zoning violation that would be enforced by the zoning division. And the final issue raised by the appellant, the owner has failed to abide by the requirements of the street cut permit. Again, required signage is non-existent. The owner has demolished the sidewalk right of way and driveway from the property line to property line and property line to street. Blocked off the sidewalk area from pedestrians and failed to follow the street cut provisions. There are no demolition drawings for this work. There's no site plan for this work will be used after utilities are complete. Street cut permits and modifications to the sidewalk and right of way is under the jurisdiction of the Department of Safety and Permits, or the Department of Public Works. This is not a CZO requirement that is under the jurisdiction of the Board of Zoning Adjustments. The department believes that the building permit was approved in accordance with the comprehensive zoning ordinance, and for the reasons stated in this report, the department's decision should be upheld. This docket was deferred at the March 6th, 2023 BZA meeting because the appellant was unable to attend. The Department of Safety and Permits does not have any additional information to provide on this matter. So that concludes my presentation. Thank you.
Is the appellant present for BZA docket number 013-23?
Good morning, Jason Thibodeau, 702 Washington Avenue. I emailed everyone on March 27th with the current issues that weren't discussed. I'm not sure, but I basically emailed all the issues only related to permeability. So I don't know if you, again, that email, I guess I could reread it. Let's see. Safety and Permits has now for the second time issued a permit based on contradictory, incorrect, and outright false data. Architect's Plan A1 calculates the lot having 3,625 square feet, whereas Safety and Permits calculates 3,691 square feet. So how can we make a determination with a survey having 1 square footage, Safety and Permits saying another? Safety and Permits overlaid their plan showing that the front steps of the property fall within the lot, and per the survey they don't. So they've actually increased the total area of the lot by 1.65 feet longer than what the survey states. So again, how can you make a determination on zoning if you have incorrect data? Next point is front porch depth. Architect's plan that was presented to Safety and Permits says it's 3 feet. Measured at 63 inches, which is 5 feet 3 inches. So how can BZA make a determination with false data? The owner has no intention of removing concrete from the sides, back, and front of house to meet the open permeable space requirement. He's installed concrete pavers, which I'm not sure counts as permeable space. It's definitely not what his plans say he's going to do. I guess do I get a rebuttal time potentially? To have more comment, I can just save that for rebuttal if needed.
You still have 2.5 minutes of time to present
Okay.
at this point,
Um,
and the clock is up to your right-hand side on the screen.
oh, gotcha. Okay. But I guess, do you have this email that was sent on March 27th? Is that in the file?
It's on page 156 of your packet.
Thank you.
So, yeah, I guess I'm confused why Safety and Permits didn't respond to this email, because it only relates to permeable open space and it contradicts what they originally did by providing a permit.
Does that conclude your presentation right now? Or was that a question?
I guess it was rhetorical.
Okay.
Yeah, I thought I emailed Valerie on Thursday or Friday asking, it doesn't, because I read Safety and Permits response and they said they have nothing further to add. And I asked basically, why aren't they responding to this when there's incorrect items? But yeah, that's I think those are pretty clear issues where you guys made a determination based on what was given as safety and permits, what was given as safety and permits was not only incorrect, but their calculations were incorrect as well.
Okay. We don't usually do the Q and A through this part, so let's at least get through the speakers
Sure.
and we'll be able to ask questions.
Okay,
Thank you.
thank you.
Anyone else here to speak in support of this appeal? PZA docket number 13-23. Anyone here to speak in opposition to the appeal?
Hey, good morning. Mike Fabry, 5269 Marsh Avenue. As it relates to the permeability, I've got a survey from Gilbert Kelly. It's also downloaded on the One Stop app that clearly shows that I meet permeability. Any issues that were also brought up with concrete will be fixed before I'm issuing my CO. Thank you.
Anyone else here to speak in opposition to this appeal? Okay, now that we've at least had an opponent, the applicant, you do have the ability to rebut if you choose to. You have 5 minutes.
Okay. In order for the current owner to keep the unpermitted addition, because it is his own personal benefit to keep the square footage, not the neighborhood's benefit, he's required to meet the rear yard setback, create new permeable open space. Because the previous owner added an addition, he doesn't want to get rid of it, so now he has to take up all the concrete in order to meet permeable space now. He has no intention of following the plans he proposed to safety and permits. If the owner had any intention to do so, he would have removed the concrete 2 months ago when he demolished the entire front concrete to do all the drainage. Furthermore, the owner actually poured concrete back into areas that are called out to be permeable ground. Owner is conveniently stating that the neighbors don't want concrete removed from the sides of their houses, but forgetting it was his decision to keep the unpermitted addition, which is why the concrete has to now be removed. Owner was given approval by S&P so long as he met the building codes, the rear yard setback, and last but not least, the open permeable space. The owner's choice is to ensure his personal benefit, the added livable square footage over what the neighbors and neighborhood benefit is why we're here. And I provided photos of all of this in the last email.
Okay. That concludes your comments. Thank you. All right, any questions from the board? I have one just that maybe help to give us a little bit more clarity. Nick, you did go over a series of bullet points with it. What was the challenge? But it seems as if though it's being presented that it's purely tied to one or two items. Could just kind of help give us clarity around what exactly are we here to address?
Yes, so my report addresses all the items that were initially submitted as part of the application. And so a lot of those topics cover things that relate to building code and other sort of things that aren't necessarily in the comprehensive zoning ordinance and aren't subject to appeal to the Board of Zoning Adjustment. So I did kind of go through individually to point out which ones appear to be applicable, which ones do not appear to be applicable. So I think what this really comes down to is the permeable open space calculation, and based on the calculation that Safety and Permits has done based on the plans that were submitted, we found that the permeable open space is approximately 35%, which would be in excess of the minimum requirement of 30%. And also just to address why additional comments weren't addressed as part of my report. So our reports are due at Monday at 5 p.m., same as public comment that anyone else has to give. I think this email was sent on on Monday, and so it wasn't even forwarded to me until after my report was already due and submitted. So that's why the additional information wasn't included. And, we go based on what was submitted as part of the application and address, those particular comments that were submitted with the application.
I think I'd understand. So just coming back to the primary bullet points as provided, we're pretty much focused on bullet point 1 from your report.
Correct. And there were a few things related to parking as well, which would be CZO requirements, but this is a particular use that does not have a off-street parking requirement. So I think that's a pretty straightforward, they aren't required to provide parking. They don't need to provide parking. So yeah, I think the property owner has complied with the off-street parking requirement, and any concerns that, there might be parking added in violation of the CZO, those would be enforcement matters that, we wouldn't issue a certificate of occupancy if they have parking in the front yard. And if they add it later, then, we would cite them for violating the zoning ordinance.
Okay. So any other questions from the board?
No, if a motion is in order.
If no other questions, believe so.
Regarding docket BZA 013-23, I move to grant. I move to deny the appeal and uphold the decision of the Director of Safety and Permits, finding that there's no error in interpretation of the comprehensive zoning ordinance.
Second.
Okay, we have a motion and a second on the floor for BZA docket number 013-23. Upholding the decision of the director, understanding that no error was found in the decision for this application request. Please vote your screen. And that motion is passed. Next item.
The next item is BZA 022-23, and the Director of Safety and Permits, Tammy Jackson, will be joining me for this one.
Good morning.
Relative to 309, 311 Decatur Street, the applicant's appeal alleges an error in the issuance of 22 ABOP-14934, the approval of occupational license number 2214885, and any of all other pending applications on 309 Decatur Street, New Orleans, Louisiana. While the appellant's letter brings up a number of matters which are not properly before the board, such as his dissatisfaction with the response provided to his public records requests, we believe that his complaint stems from a single zoning decision that informed the approval of the cited ABO and occupational licenses. An application for live entertainment license 22 LVEN 14943 has been filed but not approved, and therefore is not yet ripe for appeal. First, the department would like to point out that BZA administrative rules, policies, and procedures at section 2B, that section reads in part, the application form shall be accompanied by data required in such a form as to supply all information necessary for a clear understanding and intelligent action by the board. The department does not believe the standard was met in this case. While the letter references that the appellant believes to be a terminated conditional use, he does not provide any information as to why he believes that this conditional use was terminated. As such, the department questions whether this is a complete application. Nevertheless, we present our reasoning beside the issuance of the cited license out of an abundance of caution and to provide the board with all relevant information on this matter. In 2000, a conditional use ordinance was passed by City Council pertaining to 309 Decatur Street, permitting a nightclub on the premises. A copy of that ordinance is attached here too. In 2004, a subsequent conditional use amendment was passed to expand the existing nightclub to the second floor. A copy of that conditional use is also attached here too. While the applicant was required to record a final site plan approved by the City Planning Commission as part of these ordinances, the department and licensed applicant were only able to locate the recorded plans for the 2004 conditional use, which shows the first floor as out of scope. Copy these plans as well as plans from the subsequent 2016 permit are attached here too. After consultation with the law department, it was determined by the department that in absence of proof that the 2000 ordinance was not valid, even without being able to locate the plans in light of the perfected subsequent conditional use amendment that references this 2000 ordinance, the department should presume the law is valid. Therefore, we presume that there is a valid conditional use on this property for a nightclub. A nightclub is no longer a defined use in the CZO. However, its closest equivalent is a bar. According to the CZO's transition rules, all conditional uses and variances granted prior to the effective date of this ordinance or any subsequent amendment to this ordinance remain in full force and effect unless a conditional use is allowed as a permitted use as of the effective date of this ordinance. The receipt of the conditional use or variance may proceed to development the property in accordance with the approved plans, including all conditions included as part of the approval. If the recipient has failed to act on the conditional use or variances before the approval expires, including any periods of extension granted, the provisions of this ordinance govern. CZO 105G. Therefore, the department has determined that there is a conditional use on this property permitting a bar. Under the current CZO, a bar is a conditional use in the VCE 1 district where this property is located. Given that the conditional use is required and that the department has determined a conditional use has been obtained and that all other conditions and requirements were met, the department approved the occupational license and ABO for this property as a bar. Because of this, we ask this decision be upheld by the board. This was from the original report. We do have an update specific to this meeting. The logic behind the decision of the department is clear. There is an ordinance from 2000 authorizing a conditional use for a nightclub on this property. Number two, to date, the recorded plans for the 2000 conditional use have not been located. 3, there is a 2004 ordinance authorizing the establishment of a conditional use to permit the expansion of an existing nightclub to the second floor on this property. 4, the 2004 conditional use associated with the recorded plans show the first floor as no work this floor for information only. 5, that by directly amending and not rescinding the 2000 ordinance, the council ratified the conditional use granted therein. 6, that by approving plans showing no work on the first floor of the 2004 conditional use plans, the City Planning Commission ratified the conditional use granted thereon. 7, neither conditional use has been rescinded or revoked. And 8, therefore, the conditional use permitting the nightclub on this property remains in effect. Because the conditional use was determined to be effective, the department required the applicant to proceed under CZO 4.5F, specifying the proper process for changes to approved plan. The applicant met those requirements as well as all other requirements, and the department approved the permit. All right, and that concludes my presentation.
Okay, is the appellant present?
Good morning, Justin Schmidt.
And just to help give that clarity, Mr. Schmidt, I do notice that you do have time ceded to you, so I'm gonna give for you 6 minutes.
Right, so that should be, what is the total of 15? I've got 2 cards, I believe mine.
I'm sorry, that's right. I did have, Ms. Toledano did give you as well. So that's 9.
Total of 9 minutes. Thank you.
Thank you.
Won't take that long. Before I get started, I'd like to again state for the record, BZA rules and regulations that are adopted by this board are very clear. The procedures in which these appeals are heard. It does not include the executive director of the City Planning Commission making any statements like was done last time. He can testify after, as a member of the public, but to sit at that table is a problem and it's prejudicial. I'm going to limit, really pare down the discussion, as voluminous as it is, to my March 27th, 2023 letter that was sent in, and basically hit 3 main areas. First of all, I do want to, let me back up, want to address what Mr. Kendall said with respect to not considering this a complete application. We take issue with that mainly because you took our money, you docketed it, and if that was done, then the application was complete. I've had other situations where you have not docketed, when they felt that it was an incomplete application, they have not docketed, they have not received the money, but they hadn't, this was done via email. It was sent in. They had, the BZA staffers had time to review it for completeness. We don't believe that it was incomplete to begin with, but it was reviewed for completeness. And then a few days later, we were sent an email to pay the fine, to pay the fee, and then and with the docket number. So I just for the record, again, we see that as a spurious argument. So the first area I wanted to talk about was this presumption of validity, even though we can't find the recorded plans. And I want to remind the board that recorded plans for conditional uses are not only recorded in the conveyance records, the original conveyance records, where originals of notarial acts and other acts are kept in this courthouse, but one of the requirements of the conditional use of recordation is returning a copy of that recorded plans to the Department of the City Planning Commission, where they keep their records in the file. So what we're basically saying is in 2000, and that wasn't too long ago, it was a number of years ago, Mr. Rivers was not even an attorney at that point, being admitted in 2008. Ms. Jackson was an attorney, but doing collection work for the city, then private practice, and then some other work. I don't know what Mr. Kendall's situation was, but I started doing conditional uses in 1998. And I did a number of them over the course of my career. And I know that you always had to bring that recorded, and Mr. James will probably be able to tell you and confirm this, record those, bring a copy of those recorded plans. So what safety and permits and city planning are telling you is not only has the conveyance office lost the record, but that the very department has lost the record that should be in charge of keeping all this. And it wasn't just a paper record back then. It had to be put on disk and returned digitally as well. So you had to bring a paper record and a digital record. So there are 3 records out there that were in the possession of either the clerk of court or the City Planning Commission that are now missing, or they would urge you to say that they are missing, or that they presume to have been delivered but are lost. That's not against this applicant. That should be against the Planning Commission and the city. There's no jurisprudence or law provisions in the CZO that allow this presumption to be made. This board sees all the time situations, for instance, with the paving of a driveway. Person who has paved their front yard or is parking in the front yard is cited. They typically will come and defend themselves by saying that concrete's been down for a long time. Well, yeah, there's a presumption that it's down, but this board has always required conclusive proof that it was done within the prescriptive period or prior to the prescriptive period, and that it wasn't just, and it's prescribed as a legal non-conforming use. We require proof in this business, evidence, not presumption, hardcore evidence. There is nothing that the Department of Safety and Permits or the City Planning Commission has advanced other than the city council ordinance where it was approved and which we don't deny existed, saying that these were recorded plans. The second issue I have was a statement that Mr. Rivers made at the first hearing on March. And by the way, let me back up on the presumptions. This is a picture, ironically, of a bar on Conti Street that I took on March 6th, 2023, after I left this meeting. Filled with liquor bottles, selling alcohol. I bought a drink myself, vodka drink. They have no liquor permit. The city has issued no liquor permit on it. But are we to say that they're presumed to have a liquor permit because they're selling alcohol? There are over 20 businesses on Bourbon Street right now that are operating without the proper permits. Are we to presume that those all have permits and they just aren't posted? They're not on the Llama website? Safety and Permits has started to enforce a few of them, but there's still a lot more. This idea of a presumption is just not in the zoning ordinance. The second issue was a statement by Mr. Rivers with respect to the 3-year period. And I understand, I agree with him that the 3-year period was not clear back then in the former zoning ordinance like it is now. And we do include different language in the actual ordinances. Contrary to what Mr. Rivers said, I direct you to, and it's in the packet on Bates, the former CZO provisions, Bates stamps, page 22. Section 16.6.6 says that conditional uses will be governed by the time expirations or the time limits set forth in 16.6.11. 16.9.11. 16.9.11 talks about that. Part 1 talks about that 3-year period in which to get the conditional use started, which includes the recording of it. More importantly, section 2, and I read, this is former CZO 16.9.11.2, extension procedures. Unless otherwise prohibited by law or this ordinance, the executive director may extend the time for expiration of an approved development plan or conditional use permit or permit for the transfer of development rights for a period not to exceed 1 year upon a showing of good cause by the applicant if requested for an extension is made in writing within the original period of validity. An extension for a period in excess of 1 year shall be granted only by the original final decision maker, but not for a period to exceed more than 1 year. A determination by the final decision maker on whether to extend such a period, such approval for a period exceeding 1 year shall be made in accordance with the procedures set forth in ordinance for the original approval which the extension is requested, which basically means you need to start all over again. In this case, and we just heard it from Mr. Kendall, the 2004 drawings did not have a sheet for the first page of the first floor of where this bar is. Mr. Rivers signed plans, not 1 year. He didn't give an extension of 1 year. He didn't give an extension of 2 years. He didn't give an extension of 3 years. He gave an extension basically of 20 years from 2003 to 2023. He extended the time that this could be formalized. That was the first time that first floor records went into the public records, the first floor of the bar. It wasn't 2004. I mean, it wasn't 2004 because those things were ended. Finally.
And if you could bring your comments to a conclusion. I know we'll have time for questions.
Sure. Well, and finally, I want to, the third portion I want to say is statements made by Wheeler Manishari in her email of November 2nd, 2022, where they say, "It is my understanding that the most recent use was a restaurant, and I don't believe any interior work is planned as a part of the conversion to a bar. I will inquire to confirm, in terms of occupancy going from restaurant to bar, we aren't requiring a change of use permit."
Okay.
Why aren't we requiring a change of use permit? And I'll pick up that on rebuttal.
Thank
So just put a pin in that. Thank you.
Thank you. Anyone else here to speak in support of this appeal? Seeing none, anyone here to speak in opposition to this appeal?
Hello, my name is Allie Conley. I'm at 909 Poydras, Suite 1825. I'm here speaking in opposition of the appeal, asking this board to uphold the decision of the Director of the Department of Safety and Permits. We agree that the department has made a correct presumption. It's not a frivolous presumption. It's supported soundly by the logic that was laid out in their presentation. I was here at the last meeting and I spoke to the timeline. I don't want to belabor that or be redundant, but essentially, we believe that the interpretation of the law is correct here and that the board should uphold the decision of the Department of Safety and Permits. Thank you.
Thank you. Anyone else here to speak in opposition of the appeal?
Good morning, members of the board. My name is Ike Spears. The address is 909 Poydras Street. And I am in fact paid to be here, and I don't view that as a negative because I think when people are responsible business owners, they recognize the need to retain lawyers and professionals to make sure that they're in full compliance with the rules, regulations, and laws of this city and this state. This matter was continued at Mr. Smith's request from last month because I believe he said he needed additional time to review certain documents he had not received and to make additional submissions. From what I can tell, nothing has changed since last month. We're here to ask you to uphold the decision of the director. I also find myself being very redundant saying that I think that this board and other boards that govern business activities in the city of New Orleans need to understand that people struggle, especially post-COVID, to get back into business. And every time we put new hurdles in front of them, it's a disincentive. And we have, in this case, a responsible business owner. Jason Machado was here last year and he couldn't fly back in from Florida today. But when we say it doesn't cost to continue, it does cost to continue because I'm here and I'm charging a hefty fee to be here. If he were to be here today, he would have to, retain a flight to be here. We have a responsible business owner, operates 2 businesses in Florida. We didn't hear anything from the appellant saying that these folks are not responsible business owners. And I'd urge this board to do the right thing and to remove these barriers and allow the decision of the Director of Safety and Permits to, in fact, be upheld. Thank you.
Thank you. Anyone else here to speak in opposition to this request? Mr. Schmidt, you have 5 minutes to rebut.
Thank you. I'll go in a little bit backwards since Mr. Spears opened that door. We haven't talked about the responsibility of this business owner because it's not relevant today. This is an appeal on a technical matter, a matter of law. You're sitting as a quasi judicial board, as a judge, supposed to not on one side or the other, not protecting the city's zoning laws and granting variances like we do often, but this is a separate quasi judicial hearing under Louisiana revised statutes. The fact that this business owner, this board is supposed to protect the citizens of New Orleans, not business owners that live in Miami and operate bars.
So Mr. Schmidt, just real quick, pause time. I concur with you that we need to stay focused on what's the
Right.
items before us. So
Well,
let's keep it
Again,
pertinent to
so
that.
I just want to make sure that,
yeah.
Mr. Spears opened the door. Let's call it like it is. This is not a mom and pop operation. This is a bar that's got a national franchise.
So I'm gonna say this, we've been doing really good so far with this one of really
Right.
keeping it pertinent to the facts. Let's stay.
Okay,
in
so,
alignment. You can
so
start.
let's go back and talk about, I was talking about their email of Wednesday, November 22nd, 2022, Wheeler Manishari's, their email there. And that they conclude that email, and that was to several, that Mr. Kendall's on there, Ms. Becknell was on there, and then several members of the View Carre Commission were on there. But she concludes, in terms of occupancy going from restaurant to bar, that's an admission. That's a determination. It was a restaurant. To further amplify on that, and this is in the March, part 3 of the March packet that you have in your files, page 216 of 289, bait stamped. This is a drawing, and this is the approved stamp plan from Safety and Permits up here. This is by Brooks Grand, you know Brooks, an architect here, dated August 10th, 2015. And the red circles, although you can't see it, but it's in the file, shows dining room, main dining area, main dining room, first floor. This is what was in this restaurant. Dining is in your records, 2015. Not a bar, restaurant in the records. Wheeler Manishari's email in terms of occupancy. From restaurant to bar, we are not requiring a change of use. That is a question right then and there. I will further state, not that it's relevant for you, but there wasn't a sign permit applied for at the time because you know that sign permits trigger a VCC approval. But you know what? Now that the permits are issued, there's a pending sign application for this place. Tell me what national franchise has ever opened its doors for business in this town or else without a sign. It doesn't happen. And it only happened here because they didn't want to trigger the VCC hearing on the change of use, what's known as the 8.1 hearing, because they were then admitting that they didn't have it. So in conclusion, I want to go back through the steps. The only drawings for the first floor as a bar were done in 2000. Those were not put into the records over at city planning or at this conveyance office until January of 2023. 20 years after the expiration of the time in which that 2000 ordinance should have been completed. That is not a presumption. Those are facts. Drawings in the record is not a presumption. It is factual. Emails in the record at decision emails page 004, city email page 020, date stamped. Wheeler Manishari's, their email about it not being there. That is not a presumption. My issues with Mr. Kendall, Ms. Becknell's, Ms. Jackson's email is there was this discussion.
I'm trying to bring your rebuttal to a close.
Sure.
I don't know.
Based on our discussion, in the absence of proof, the 2000 conditional use is invalid, we must presume it still to be valid. That's not how conditional uses work. Conditional uses are special permits. They are to be construed strictly because they are permitting something at a heightened level that you're not entitled to by right under the zoning ordinance. So we don't presume that they're valid. We have to have evidence that they're valid, and there's simply no evidence here. Thank you.
All right, thank you.
If you have any questions, I'd be happy to answer.
Yeah, don't go too far. Any questions from the board? Just a couple points, Mr. Smith, that you brought up early during your presentation that I feel is just necessary to address. We did have a little bit of confusion in terms of pertinence of presentation last time. And just from my particular standpoint, I think it was still pertinent to still have information provided by Mr. Rivers, at least here. Yes, I do agree that the decision we're reviewing is purely from the Department of Safety and Permits. That's pretty clear. That's our rules is spelled out, and even as I provided it earlier. In the case of conditional uses, I know that how those applications go through, you even called, even suggested my experience of those. But often I notice I need to confer with both directors to have clarity on history of some of that documentation. So I do believe his information is still pertinent to what we have, but I do acknowledge that he did not present as a part of what we had here. And if anyone from the board has questions of Mr. Rivers, they have the ability to request any commentary from him during the Q&A portion. So I just felt it was important to at least address that because it was important to concern yours in your early.
No, it was, and I still renew, my objection and my motion to strike his testimony that was gratuitous at the last meeting, because I think it is prejudicial. The rules and regulations are straightforward. They're clear. Mr. Rivers felt like he had to defend himself. Well, he can defend himself on this side of the glass, not sitting at the table where it's prejudicial.
So I think as long as he's on the other side of this dais, I treat it the same
Well,
space.
okay.
So we're
Fair
fine.
enough.
That's the first part. Getting back to applications and how they may be processed, dating back to the old TZO. Often you may have had projects that went through, but in this case of this particular property previously, when the conditional use was applied for, was a certificate of occupancy ever issued on it beforehand? And that would be a question to department is aware of that.
Yeah, I don't have that information in front of me. I mean, we can try to look into that real quick. I'm sure at some point a certificate of occupancy was issued for one of the businesses here. I don't recall, if we have those available records for what happened post the 2000 conditional use to see if a certificate of occupancy was issued, but we'll see if we can find something.
Okay, the reason why I bring that question up, traditionally in the review process, I've handled this on projects myself. I'm sure pretty much any other design professionals handled a conditional use application on behalf of a client. You go through that process. I do agree, traditionally, you're supposed to have that information filed with the clerk, and it's supposed to be turned back into CPC. There's also a check process on the tail end to confirm that with that project, before a C of O or anything to that effect is issued, all zoning compliance and all other items have been reviewed and conferred. My concern is from that time period, if the C of O is issued for the previous occupancy, there's some assumption that may go into play that the conditional use process or the zoning process has been completed. Would you agree with that?
Well, I agree if it was in the record. And that's one of the reasons why I asked for the deferral last time to review this email that Ms. Jackson had, that basically the director had made it on, because I wanted to see what the documents were, what exactly was she reviewing to make this presumption. I will tell you, years ago, St. Andrew's School on Oak Street, I did a conditional use for it, new building on the corner. The architect didn't record the plans, the final plans, after he worked out the details within the 3-year period, and we had to start all over again. You'll see on that docket, there was two, we had to go through the conditional use process again.
But work was completed, correct?
No,
Well,
work had not been completed.
Okay, so I think there's a big difference between construction commencing and a permit being issued versus a conditional use application starting and that window of time in which the conditional use still is valid and in good standing if construction has not commenced. I, in a professional capacity, have all the time had to go back to the director requesting extensions of times that you mentioned, the 2 1-year extensions.
All right, but in this case, the extension, the permits that they were seeking to renovate for the bar were not issued within that window.
The permit was not issued?
The building permits, the alcohol permits, none of those were issued during the window. They were only issued after the 2023 plan recording the 2000 plans. They were after the so this applicant took, Mr. Rivers signed the 2000 and 2004 plans in January of 2023 and called that compliance with the conditional use ordinance. And that's what I'm saying is the problem. It was 20 years from when that 2000 conditional use permit should have been completed, that those plans showing the bar, which would have legitimized the bar, existed and were filed in January of 2023.
So
20 years.
So no permits in any capacity for an operating business.
Yeah, restaurant. And there might have been a bar too, but there was a restaurant. We went through a 2004, there was a 2004 conditional use, but it didn't have the first floor as a bar in it.
All right, and I understood that from your presentation saying that.
Right.
You said that Mr. Kendall acknowledged that the first floor page was missing from that document.
No, it wasn't missing. It said not part of this project. No, it was in there. It just says not part of this project. So the first time in the history of the world.
I'm not gonna go that far, Mr. Chairman.
That's the first floor plans as a bar was reflected in any public record, either in safety and permits, city planning, or the conveyance office of the clerk of Orleans Parish, was in January of 2023. I don't care about the presumption, because you know what? This is a presumption. We presume that they have a permit, but they don't. We presume that 20 other, are you suggesting that safety and permits never issues permits that shouldn't be issued? Come on.
You know, you and I are not gonna do that right now.
Well,
So here's the question. I mean, that's the whole premise of why we're here, why we review.
Mr. James, there's a fix for this. They should have told them to go back and file a conditional use permit.
So I'm gonna come back to my question, because I think we.
Because there's a fix.
Well, hold up. 2 different lines. If a building permit was issued in any capacity for the initial use that was spelled out within the conditional use of the previous date, do we have any record of something to that effect? I understand what you're talking about. What was
Certificate of occupancy, where is it? Certificate of completion, where is it?
You heard me ask the question.
Yeah.
So I know they're looking for it.
I mean, they've had these records for, they've had an extra 30 days to find them, and they didn't put them into the records.
Well, I don't think we presented that question last time, but go ahead.
Well, but I mean, I guess what I'm saying is they knew I was coming.
Well.
Yeah, I mean, I'm not, as you know, Mr. James, I'm not quiet.
I'm aware.
So they knew I was coming. They geared up, they brought down the big guns.
That's why I have my
Miss
call.
Jackson's here herself.
So, Nick, have you had any chance to dig further into what you guys may have record of?
Yeah, so I do have kind of a few responses on multiple issues related to this. So first off, I think, we do come across situations where, conditional use is approved, plans might not have been recorded, maybe a building permit is issued, they get a certificate of occupancy. Typically in those cases, we would treat that as like, okay, they never completed that conditional use, you now have essentially a non-conforming use moving forward. So that's how we've treated that. And if that was the case here, that's the decision we would have made, that this was a non-conforming use. That non-conforming use went away when it became a restaurant, and they would have to go get a conditional use for a bar. What's different in this particular case was there's that subsequent conditional use amendment in 2004. So that was an amendment to the original conditional use to expand the existing nightclub. And because of that amendment, that essentially, reapproved the original conditional use and allowed it to expand. So I don't know if we would say the expansion was allowed, but the original nightclub wouldn't be allowed to operate anymore. But because we do have that second conditional use with recorded plans, the bar was not shown on those plans. We do have the plans. It just shows that, the plan set says no work to be done in this area, which is common when we have,
But any
these sort of
permit application,
situations.
the
Yeah.
scope of work is not applicable in that area, but go ahead.
So we do have recorded plans for that. That was an amendment to the existing bar. So so we do have a different situation here, and that's why this was kind of a difficult case for us internally. Like, this wasn't a slam dunk to say, okay, yes, this amendment was passed. And so, yeah, we did have to confer internally. There's conversations between safety and permit, city planning, the law department, and ultimately we came to the decision that we did. With regards to permits, I'm able to find permits related to the 2004 expansion showing that, permits were issued, there were final inspections. From what I can quickly look up on my phone, I didn't see an actual certificate of occupancy. I did see a final inspection that was approved for the 2004 permits.
Okay. So
Yeah, and which we don't, and that's actually why we appealed, because we agree you can run a supper club there. 2004 is good. Run a supper club. That's what you're entitled to do. Supper club, by the hours of the supper club, by all the provisos in the supper club, in that approval, because it doesn't say bar in the 2004. It doesn't say nightclub in the 2004. It says supper club. And again, the first floor plans did not show up until 2023.
So a question of staff. Or in this case, this is when I would ask Mr. Rivers in the difference between a 2000 versus a 2004 conditional use application. So I think your information is pertinent. If it's if it was an amendment to an existing conditional use, is it the assumption that whatever was in place before continues with the modifications of the later document? Or is it to be presumed that in this case, this is a different use application and the uses would change from, let's say, a bar to a restaurant or supper club, excuse me? Because where my mind is going is if Mr. Smith's argument, he's talking about in a supper club configuration, that's a different use. So to me, I don't review that. I would think that's not an amendment. I think that I would look at that as a different conditional use application, but that's me. So I'm just asking if you could provide any color to that.
So when my staff and
Just
I,
real quick, I just want to make sure we're keeping it purely to just
Sure.
how those occur. And that's the question.
sure, when my staff and I reviewed it, we reviewed it as a bar, which was what was being applied for, and whether that bar was consistent with the provisos and the requirements of the approved 2000 conditional use, which is frankly the same way we would have reviewed it had it been submitted as an amendment to a prior conditional use. In this case, because there were no plans that we had to look at a change, we just reviewed it as an original submission, whether those plans were consistent with the approval that was granted.
Okay, I'm gonna think on that. Coming back to the plans. Mr. Kendall did present to this point, and I think this is gonna help at least give me some clarity on that piece. The second set of documents excluded the first floor, and that is typical, which you would see with any set of architectural plans that are submitted, unless it's required by safety and permits to provide the existing first floor plan at that time. I know Mr. Rivers can't speak to how it may have been reviewed in 2004 because he wasn't in the department, but he has to still review it with some level of appreciation of how it would have occurred in some capacity. So some grace has to be extended in that point of responsibility.
I don't know where the code says some grace is applied. I mean, this is black letter law, Mr. James.
Oh, I agree. There's black letter law.
And
but
it is a
again,
very,
it's-
there's a
it's
very,
loose interpretation.
there's a very, there's a very, very definite procedure for doing conditional uses.
Mhm.
And it's set forth in the zoning ordinance and it wasn't followed here. And that's the issue that's before you. And so, yeah, that sucks for the owner that came up from Miami to put a new Shots bar there. But they could have, and that's the irony of the whole thing. We pointed this out to safety and permits in June of 2022. They could have applied for a conditional use permit and had it probably by September instead of waiting till January. Because they started putting on their Instagram account that you can see in there that they were ready to open up in July. So they're getting information from the city saying, oh, we're getting ready to open up. And then we kind of dumped a bunch of stuff on them and the city started saying, oh, at first it was, oh, well, because the former CZO doesn't handle, it doesn't have because the new CZO doesn't have the definition of a supper club in it. We're just going to make it a bar because that's what it was before.
Okay. So I'm gonna come back.
That's in the record.
All right, so I'm gonna come back to my question because I really need to think on it back of my mind. The earlier question I had to Mr. Rivers was, so when you did that subsequent review, you are still looking at it purely from the use that was allowed beforehand. Would the amendment to the conditional use strike that initial use application, or does it get preserved and a new use is also amended to that conditional use?
I'm not sure I understand the question.
I understand. And my appreciation of this, I don't mean to jump all over you, but I would say it is a sui generis.
Respond, but then
It's a sui generis application, and I think it says whatever the ordinance does whatever the ordinance says it does. Sometimes they amend it, sometimes it is redacted in its entirety and reapproved, then this is it. I, in fact, am doing this over on Carondelet Street, where a building has a restaurant in it and it's got a Pizza Hut in it. I mean, a Domino's. It needed a
okay, all right,
Domino's.
so that helps me. Within the 2004 amendment, did it strike the bar as a use? Did it strike bar as a use?
I have that language up. So in 2004, what was approved was an ordinance to administratively amend ordinance number 19957 MCS zoning docket 118-22, an existing conditional use to provide for the establishment of a conditional use to permit the expansion of an existing nightclub to the second floor in the VCE1 district. So the 2004 wasn't amended to expand the nightclub to the second floor. But the part on the second floor was a supper club, and there were specific rules around the supper club on the second floor. So if this particular bar wanted to use the second floor, they could use it as a supper club in accordance with those provisos that are in this 2004 ordinance, but they're just using the first floor as a bar based on what was approved in 2000, and the 2004 ordinance was an amendment to the 2000 ordinance.
So I'm good on that. Actually helped to give me the clarity.
And that's actually not what happened though. That's the summary of it, but it was after that 2004, the whole business acted like the supper club. And again, we go back to the 2014-15 stamped approved drawing showing again the dining room configuration for Ted Brennan's restaurant.
So I'm gonna come back to a point you just reminded me of. I gotta look at the black and white letter of what was in that ordinance document, what the intentions of it was versus what the actual ordinance stated.
That's what we've said from day one. This is a supper club because that's what the ordinance says it is.
Well,
so you can't operate a bar at a supper club.
Not supper club. What the ordinance didn't state supper club,
but
when it stated nightclub, correct?
That was a summary. Let's read the actual ordinance. Let's read the actual term, not.
Do you have it? I mean, because
not the preamble, because that's the preamble, and we know that preambles aren't the law.
But sometimes that's the intention, so I get that as well. But let's make sure we're clear on what. Can we please? Thank you. We're not gonna start that up again either. There was enough heckling last month. So what did the actual ordinance state in terms of final use? Because that's what I'm interpreting from safety and purpose.
Do you need the language of the
Yes, please.
2004? This is copy from yours.
Yeah, that's fine. Whatever's in the record is fine.
I just want to make sure I'm looking at the right thing. So within further definition of the ordinance, does it spell anything else spell anything else out differently in terms?
The proviso, I mean, the provisos are for the entire property.
Mhm.
And that's the issue. It's not just the second floor. It's that they were operating a restaurant. They weren't operating a bar on the first
But
floor.
it still says the previous ordinance.
It's sloppy. I'll give you that. It's not, it's as dirty as mud.
Well, I agree. And look, I mean, it comes down to how it was processed back in 2024. I mean, if the 2000 conditional use wasn't properly recorded, then it shouldn't have been allowed to be amended in 2004.
Well, I don't disagree with you
So,
there.
but
that's why I go
let's
back
at
to
least
let's.
acknowledge where the inherent confusion lied. So
Well, I don't
it-
think
it
there was
does
confusion.
date back to that period, but then the work and everything else had been completed in conformance with the 2004.
Well, this is what's troublesome. It's again, I go back to Wheeler's November 2nd email. That's where I have a problem with this. In terms of occupancy from restaurant to bar, I mean, the department, Wheeler is the assistant zoning administrator. The zoning administrator is saying it's a restaurant. Going to a bar.
You have anything?
And I mean, that's a whole different question is why she says we aren't requiring a change of use permit. But I mean,
Look, I've sent questions myself on projects where that has happened, and it's been further clarified whether she provided.
not in the record though.
or not.
Where is it?
So-
Where is it in the record? Where
But I think it ultimately does defer back to what is within the letter of law and how it was actually executed within the ordinance. Unfortunately, from the 2000 to 2004 scenario, the amendment technically shouldn't have been processed, but it was.
I don't
And
disagree
then
with you, right.
finalized into record, which provided some level of establishment that the earlier document
Right.
still existed.
a non-conforming use then, is what we have, which was terminated when it became a restaurant.
So let's say when a property transferred, let's say Mr. Schmidt, you and I go in business, we go acquire this property, we want to open up some type of restaurant establishment at this site. When you and I acquire that property, certain documents are transferred with that acquisition. And if there's a ordinance that shows some level of a conditional use applied to it, saying that some uses are applicable, you and I would move as if though that was our allowed right, correct?
Right. Conditional uses run with the property,
Correct.
not with the.
They
owner,
transfer.
The operator and they transfer with the prop. They run, as we say in title work, and run with the
Mm-hmm.
with the land.
So if it ran.
But that's what I'm saying is we don't have evidence that it was ever in the land.
Well, we do from 2004.
Right. But then as a supper club, not as a bar on the first floor. Again,
Saying
nothing,
that it can expand within a property, and that's even what
but
was
there's,
spelled
but
out.
you see, that's where you're forgetting that there's no record in the public records
Of 2000.
of it.
No, I agree.
Of anything of a bar being on the first floor.
But again, I'm not declining that, right?
Right.
But apparently it gives some inclination that that type of use was within the facility, whether the drawing was there or not. So apparently in 2004, when it was reviewed, it was understood that that inherent use and function was there. I don't know if it's documented through photos. We don't know if it's documented in some other way when the application was processed, but I'm sure the full record probably didn't confer going forward, especially considering we're talking about a 2004 permit. We know what happened the following year.
Sure.
So often, who knows what happens with these records, and they're only stuck with making a decision based off of the information that's before them at that given point.
Well, there wasn't Katrina in 2000 or 2001, 2002, 2003.
But there was one in 2005 after the
Right, but
2004.
where
amendment.
the
So I'm
2000
only
line?
talking, but here's the thing, don't use that line to confuse it back. I'm coming purely from the 2004 conditional use amendment. which
Those were recorded though.
Of course, that's kind of my point. Like, there's that information, but what happened with the actual application in the beginning in order for it to be reviewed by CPC to assume that the conditional use was being amended? I'm sure something happened earlier, even before 2004, that provided some level of information to show that that use was in place.
Well, no, it would be helpful to go back and find the video of the city planning, the city planning commission and the city council hearing on the 2004 amendments. Unfortunately, those aren't available on Granicus. Now, I don't know if Mr. Rivers might be able to opine if those are in some safe somewhere, but that would ultimately be the way to solve it, to see exactly, you talked about intent earlier. We could see exactly what the intent was doing. And I'm saying based on the conversations we've had with the neighbors and everybody that was around at the time, again, none of these individuals were around at the time, but based on the individuals that we've talked to that were around at the time, they're all saying that this was going, that the 2004 supper club. And likewise, they did another supper club across the street on the corner of Bienville and Decatur. Those were very popular in 2004, apparently.
So I feel like I'm also being unjust by not providing my other board members with time to ask questions instead of me just going back and forth. So
I like talking to you, Mr. Jones.
I know, you too, Mr. Schmidt. Any other commissioners have any questions at this time?
I think I'm going, if it had the conditional use and then became a restaurant, does it lose that conditional use that was previously there? It's still occupied, right?
Yeah, the conditional use stays with the property unless the conditional use ordinance is rescinded. So even if it was a restaurant for 10 years, that conditional use, as long as it is still mapped on the property, still in effect, and they can come back and do what was approved in that conditional use.
Okay, and then the first proviso says that the stated that the live entertainment shall be limited to the first floor shall be eliminated, right? So that's saying that the upper level can be used for, to allow the expansion of that nightclub into the second floor, right? That's the way I'm interpreting the language there.
Correct. And it goes on to say all other provisos for the original ordinance shall remain in full force.
Right.
On the subject property. So yeah, it intends to keep the original conditional use and all the provisos associated with a nightclub on the ground floor. And this amendment allows for that supper club on the second floor.
Got it.
So that comes back to, that's why I asked the situation, if we were to acquire it, it runs contiguous with the land. Yeah. And there hasn't been any record in the past where, let's say if a scenario like this plays out, when does something get grandfathered? That's not the case, because in conditional use land, it runs in perpetuity.
Thank you for the clarification. I just want to make sure that I got it with all the back and forth. It was
Yeah.
just want to make
You
sure
know
it's
me and
really
Mr.
clear.
Schmidt like talking. Any other questions from the board? It's the pleasure of the board. And if anybody needs any other questions, we've at least established a chain of communication with CPC with regards to anything pertinent to the conditional use application process.
Regarding docket number BZA 022-23, I move to deny the appeal and uphold the decision of the Director of Safety and Permits, finding that there was not an error in the interpretation of the comprehensive zoning ordinance.
I'll second. Yes.
We have a motion by Commissioner Rufo and a second by Commissioner Diaz to uphold the decision of the Director of Safety and Permits, deeming that no error was found in their determination. Please vote your screens. And that motion has passed. Thank you. Next item.
We will now begin with the new business for variances. Go ahead, Sarah.
Next item is BZA docket 024-23 for a property located at 5845 LaFay Street. This is a request for a variance for the provisions of Article 13, Section 13.3.A.1, Table 13-2 of the Comprehensive Zoning Ordinance to permit the construction of a single-family residence with insufficient corner side yard setback. Article 13, Section 13.3.A.1, Table 13-2 requires a minimum corner side yard setback of 10 feet per the SRS Suburban Single Family Residential District. The applicant is providing 3 feet and is seeking a waiver of 7 feet. The staff believes the request does satisfy the 9 criteria as they pertain to the requested variance. Therefore, the staff recommends approval of the requested variance subject to 5 provisos.
Is the applicant present for BZA docket number 024-23?
No, I'm not the applicant, but I'm here representing him in his absence.
That's fine. Okay. You have 3 minutes.
No, I'm just an investor that flew in from Atlanta. I was told to stand in because he had to go to California.
All right, name and address for the record.
Damon Crump, 216 Prestwick Way, North Stockbridge, Georgia.
Thank you.
And I'm here. He was sharing that there's just not enough room to be able to do what's needed, I guess, in having a yard space or side space. So just was asking to give a little more room to go further out.
Okay. And y'all have had a chance to review this and understand the approval and provisos. Are you aware that they reviewed the document?
Yes, yes.
Thank you. That's it?
That's it.
All right. Anyone else here to speak in support of BZA docket number 024-23? Anyone here to speak in opposition to this request? Seeing no movement in the room, is there any question from the board? It's the pleasure of the board.
I'd like to make a motion
Proceed.
in regards to BZA 024-23. I'm gonna move for approval. Following the staff's recommendation is subject to the 5 noted provisos.
9 criteria.
Oh, sorry. Finding that the 9 criteria have been met and following the staff's recommendation, I'm gonna move for approval, subject to those 5 provisos.
Thank you. We have a motion on the floor. Do we have a second?
Anybody?
Second.
We have a motion and a second on the floor for BZA docket number 024-23 for the requested waiver of Article 13, Section 13.3.A.1, Table 13.2 for corner side yard setback and the move for approval with the 5 noted provisos, understand the 9 criteria have been met. Please vote your screens. And that motion is passed. Next item.
BZA docket 25-23 is a request for a variance from the provisions of Article 21, Section 21.6.T.3 of the Comprehensive Zoning Ordinance to permit ground-based mechanical equipment, in this case, a generator, located in a corner side yard. This is an after-the-fact request. Staff acknowledges that denial of this request would impose a hardship on the applicant, as it would trigger a need for additional gas and/or electric lines to be located at the rear of the site. However, staff finds that the request does not meet 2 of the 9 criteria, and that literal interpretation of the ordinance will not deprive the applicants of rights commonly enjoyed by other properties, and the variance will confer on the applicant special privileges. Therefore, staff recommends denial of the request. However, if the board decides to approve the request, the staff recommends 4 standard provisos.
Is the applicant present for BZA docket number 025-23? come up and just provide your name and address for the record, if you don't mind. You
Ronaldo
have 3 minutes.
Partesotti, 4735 Carendolet, I'm the owner of the property. We hired a national contractor to do the installation of the generator. And now to relocate it as they requested would create a hardship, economical hardship, because of the problem of relocating the line, as they said, and the problem also breaking up flower beds and other things that are in the back of the property. Additionally, if we were to relocate it to the back of the property, it would interfere with the property next door, which is not being taken in consideration or recommended. So we ask that you grant our request for the generator to be located where it is right now. And thank you very much.
Okay, thank you. Anyone else to speak in support of this request? Anyone here to speak in opposition? Okay. The only thing I will mention, just so that you're aware, often because of how 9 criteria is spelled out, we traditionally cannot listen to economic hardship as the justification for the request. We have to look at it purely through the context of the 9 criteria, and that actually is one of them, that it cannot be a fiduciary situation.
The one that I think is most important is actually the fact that if we were relocated somewhere else on the property on the back, it would definitely create an interference for the property next door because of the fumes that come out of the generator when it's there.
Okay.
So that to me is the most important consideration, but the hardship also is a consideration too.
Okay, thank you for that clarification. Any other questions from the board?
Yeah, I guess I was trying to understand the side yard that exists for the building. It seems like it's pretty close to the corner currently. Am I right? It's 4 foot something to the. So I guess my question for the staff is, can the generator be located within the alignment of the house and like that nonconformity, or does it?
That step back?
The setback, yeah. Because that would put it a little bit on the property, but not, it would be if the side yard is interrupted by the building anyway, is it still a side yard?
If I may, it
I
would be,
was gonna ask the staff first and then.
yes,
we can- No, so the side yard is interrupted by the building, right? So where do you measure the side yard? If the building currently is 4'5" or 4'4" from the property line now, how do you measure the side yard? Is it from that bump out on the house that's close to the corner, or is it, unless I'm not reading the plan right?
That is correct. You measure the wall that's closest to the corner side lot line, and that sets the corner side yard setback.
So that would, instead of the generator being 10 feet from the property line, it could be 4 feet from 4 from the property line? Is that right?
It could be. I'm not sure if there are doors and windows in that particular section, but hypothetically, yes.
Yeah, that's what I was gonna jump on next, was the problem then turns into if there's any bedroom windows in alignment with that plane or operables. I think it has to be 10 feet away, I think or is it less than that? I forgot what the code requirement is for that.
I believe it's 5, but according to Google Street View, there are windows in that area on both the first and second floors.
But it would be possibly not actually in front of the building, right? It would be I'm trying to look at the street view. There's the bump out. If the generator pushes back a little bit, it's still within the yard, not up against the building, but I guess.
If I may, even if you move it closer to the corner of the lot in the back, you talk about relocating it from where it is to about 3 feet away or something like that. So it's not really relevant to what we have there right now.
Just a quick question to staff. I don't want to go too far out of range. There's an image provided on page 31 of the report. Is that in your slideshow? The image on page 31 within the staff report. Or at least I could just at least direct everybody just to, within a report, there's the image that shows that the generator is actually behind a shrubbed fence. And just kind of understanding what we have done in the past, I think we may have had this come up, if not last month, within the last 2 or 3 months. There was a similar application where this corner side yard condition was had, but it was, I think in that case, it was a front yard as opposed to a side yard. But what was at least recommended by staff and what I believe what we took action on as a board was because that equipment was screened off in some capacity from the public right of way, or at least from public view, we granted some level of.
Yeah, it is
exemption in that
screened
case.
and is open too, so.
Yeah, no, and I appreciate, just give me 1 second on that.
Sure.
And understanding that type of condition, I think if we were to do this, I think staff even gave 4 provisos that could be, yeah. Don't worry about it, Val. Because that type of, we've done that in the past. I mean, I think that's further justification around this exclusively because this is tied to some level of screening from public right away. And even as the applicant provided in his comments, if it's shown on the opposite end of the property, which is traditionally where we would want this, it may be too close to the neighboring structure.
Yes, on both sides.
Yeah,
On the,
in the rear yard, if it was pushed back
Yeah.
further into the rear yard or pushed to the opposite side of the property.
Yeah.
Towards the interior side yard. So I think it's helpful to look at the images provided on page 33 and 31.
Val, can you advance the next slide?
So this is just.
And I think, yeah, even within this image, the one that's shown in the upper right-hand corner shows the masonry wall that's screening it from the right of way.
Shrub.
Correct. Which at least gives you some form of an acoustical protection value.
Staff, quick question. Just wanted to recap your notations on the provisos and how many there were if we were to decide to grant the variance. How many were there?
There are 4.
There were 4. Okay. Thank you.
And if I could clarify, I don't believe they're in the staff report, so it would be the standard 3, as well as compliance with Article 21, which requires the screening of the equipment.
Thank you.
But understanding that it's an existing screening, not sure if it's 100% in compliance with that section.
We would have to verify.
Yeah. Okay.
Any further questions?
Motion's in order.
Proceed.
In regards to BZA docket 025-23. After further conversations and looking back at some historical patterns of what we've done in the past, I find that we should move to approve the docket, finding that all 9 criteria have been met. And we approve it subject to the 3 standard provisos and the 1 additional proviso notated by Emily regarding screening and proper screening for this location.
Second.
There's a motion on the floor. There's a second.
Yeah, second.
Only thing I would just note to it. I think that would be subject to the review of BZA staff against that article. That would probably provide the correct documentation just in case if 100% of the screening language isn't met.
That's correct.
Okay. Does that provide, would you like to
Yeah,
amend the motion?
amend the motion to add the language from Commissioner James.
Okay.
If you want to tell me the specific, that specific item again, I can also add that to the motion regarding the proper screening.
I can
for
read
this
it.
equipment.
Want me to read it in?
Sure.
The regulations found in Article 21, Section 21.6.t of the Comprehensive Zoning Ordinance, including screening of the mechanical equipment, so no portion is readily visible from a public right-of-way.
And I think what I was mentioning was more is subject to the BZA staff review, because if it's just spelled out that way, it may not be 100% compliance. I want it to at least fall to you guys.
Okay, so in addition, subject to the review and approval of the BZA staff.
Thank you.
All right, we have a modified motion on the floor. Do we have is the second?
I second
All right,
with the
thank you.
revisions.
Thank you. All right, we have a motion and a second on the floor for BZA docket number 025-23 for the requested waiver of Article 22, Section 21, Article 21, Section 21.6 T3 for mechanical equipment locations. Granting the request and following the board's language that the 9 criteria have been met, and move for the approval with the 4 noted provisos. Please vote your screens. And that motion is passed. Next item.
The next item is BCA 02623 for a property located at 8133, 8137 Green Street. This request is for a variance from the provisions of Article 11, Section 11.3A1, Table 11.2A, Article 11, Section 11.3B3A, Article 22, Section 22.8A1B2, Article 22, Section 2211.B.1, Article 22, Section 2211D1, Article 22, Section 2211D2, and Article 22, Section 2211D3 of the Comprehensive Zoning Ordinance to permit a 2-story family residence with excessive impervious surface in the front yard, insufficient permeable open space, more than 1 curb cut, and a parking pad located between front facade and front lot lines with insufficient setbacks from front lot lines after the fact. During the course of staff's review, staff found that the use of the site is unclear as there are 3 active gas meters, 1 active electric meter, and 2 dwelling units. Due to this, staff has requested a use determination from the Department of Safety and Permits to ensure proper review and analysis of the staff's requests. Staff therefore recommend a 30-day deferral of this request.
Is applicant present for BZA docket number 026-23? Anyone here to speak in support of this request? You're in support of this item, correct?
Hi, I'm a neighbor of, I live across the street from them across on Green Street.
So if
And,
just your name and address for the record, please.
I just wanted to say that I think they've
Need your
improved.
name and address for the record.
What?
Your name and address for the record.
Sylvia Cameron, 8201 Green Street.
Thank you.
And I just wanted to say, I think they've improved the neighborhood. They've increased parking for the neighborhood. I notice here that you have it listed as a traditional two-family home, but I don't think they're using it as a two-family home. They go in and out of just one side of it. And I think I know why they're parking in the front. They've put a gate around it and it's to protect their car. And they've landscaped the front, so it looks really nice. And they're keeping their boat on the side. And they used to have it on the street, so they've increased the parking for the neighborhood. I think it's an improvement. They've renovated the house. They haven't changed the look of the house in any way. So I think it's a good change. And that's all I have to say. Thank you.
Thank you. Anyone else here to speak in support of this request? Anyone here to speak in opposition? Okay, I know we have a recommendation from staff. What's the pleasure of the board?
For motions in order. Regarding BZA 026-23, I move for a 30-day deferral per the recommendation of staff.
Second.
Okay, we have a motion and a second on the floor for BZA docket number 026-23 for a 30-day deferral. Please vote your screens. And that motion is passed. Next item.
The next item is BZA docket 027-23 for a property located at 2428 Murray Street. This request is for a variance from the provisions of Article 11, Section 11.3.A.1, Table 11-2A, rear yard setback, and Article 22, Section 22.4.A, Table 22-1, off-street vehicle and bicycle parking requirements to permit the construction of a new two-family dwelling with insufficient yard setback and insufficient off-street parking. The HURD2 district requires a minimum rear yard setback of 20% or 15 feet, whichever is less. The subject site measures 68 feet in depth. Therefore, a rear yard setback of 13.6 feet is required. The applicant is proposing a rear yard setback of 4.77 feet and is requesting a waiver of 8.83 feet. The proposed two-family use is also required to provide one off-street parking per dwelling unit or two for this site, is proposing none and is requesting a waiver of 2 parking spaces. The staff believes that the requested waivers of Article 11, Section 11.3.A.1, Table 11-2A, rear yard setback, and Article 22, Section 22.4.A, Table 22-1, off-street vehicle and bicycle parking requirements to permit the construction of a two-family dwelling with insufficient rear yard setback and insufficient off-street parking fails to meet standard 3, 6, and 7 of the standards of variances of Article 4, Section 4.6F of the Comprehensive Zoning Ordinance, in that the special circumstances were caused by the applicant. The property regulations will not result in a demonstrable hardship, and the change is exclusively for the convenience and profit of the owner. Therefore, the staff recommends denial of the requested variances.
Is the applicant present for BZA docket number 027-23?
Robert DeLon, DeLon Investment Services, 401 Sharon Drive, the owners of 2426, 2428 Murray Drive or Murray Street. And I'm here to speak on the 3 items that are pointed out in the staff report that says the standard is not met. Initially, before I do that, I would like to say that this property was a nuisance property in the neighborhood. It was undeveloped, overgrown with lots of debris and trash, as well as drug paraphernalia and vagrant activity. Since we have purchased it, we have cleared that lot, and we're gonna, planning on putting it back into commerce to get rid of that nuisance in the neighborhood. Also, just in regards, there's a uniqueness to this lot because in the rear, there's actually a parking lot to a Chase Bank. So there's no property in the back, just for consideration on this rear yard setback variance as well. So I would like to go ahead and speak on item number 3, standard is not met. Do any special conditions and circumstances result from the actions of the applicant or any other person who may have or had an interest in the property? It's stated that there's a common ownership with those lots presently and under the same tax bill of 1128 and 1130 Music Street. This lot and the 1128 and 1130 Music Street lot are separate lots. They have always been separate lots. We purchased what is considered Lot B from the previous owner who owned both of those lots. So there is no common ownership. So this statement in here is incorrect. Now, the tax bill is currently under the previous owner's name still. We have been working with the tax assessor's department. We've submitted a request to get this lot's tax bill separated from the other lot. So that's in the works, and there is no ownership interest with the other property owner at this time. In regards to item 6 and 7, which is stated that the standard is not met, I would like to point out that in the review by the staff in the report, that this is a substandard lot. It's 68 feet in depth, which this zoning district calls any lot that is not 90 feet in depth a substandard lot. Hence, the issue with, trying to meet the setback in the rear yard as well as the parking requirements. Based on the staff report, I've stated this is a substandard lot. There are 7 substandard lots in this square. And of those 7, 57% of them, they have a variance of a rear yard setback. So I just wanted to note that. And then since 2015, on 2 family parcels in this square, there have been 10 requests for variances, 7 which have been approved and 3 denied. So there is a precedent that has been set previously for approving this requested variance. As well as, I would like to point out that in regards to the parking variance, that a majority, 68% of the 28 two-family lots that were surveyed, they're either exempt or not compliant with the parking requirements. So there is a precedent in this square that 68% of the properties do not comply with the parking requirements. So therefore, based on the precedent that has been set by this board previously, that the majority of the lots within the area that are substandard do not meet the rear yard and the parking requirements, as well as the majority of the 2-family lots within the area do not meet the parking requirements, we request approval of this variance.
All right, that concludes your comments.
Yes.
Thank you. Anyone else here to speak in support of BZA docket number 027-23? Anyone here to speak in opposition? Questions from the board?
Question the applicant. In the staff report regarding the 20% rear yard setback requirement, they notated that that standard had not been met, because the development could be designed that would allow for that 20% rear yard by adding a second story. Have you guys looked into that so that you could come into compliance with that that proviso?
We have looked into it, and adding a second story would require to put sets of stairs within the two units, which although is considered part of the square foot living area, is not actually square foot living area. So we would actually lose square footage if we were to build this and adhere to all setbacks and parking requirements, because we would have to have a stairwell within the units themselves.
So, no. Traditionally within a design stair, I mean, I was trying to be nice on that one. It's just the layout of the plan right now. The way the plan is situated, it's just a mirrored floor plan, and that's what's causing the encroachment into the setback condition. If the plan was truly studied by someone who did architectural residential plans, you could come up with probably a myriad of design opportunities within this plan to still meet what's the desired outcome. Just trying to say that qualified square footage due to stairwells doesn't really jive, because even within a stairwell, within a unit, there's a certain amount of square footage area under the stair riser condition that you could still make for half bathrooms, a whole list of other things that still falls under the qualified square footage of that unit. Yeah, just Rami.
Well, I was gonna say, the typical lots in New Orleans are 30 by 120 or 30 by 100. And so to say that, this is a shorter lot, sure, there's a lot of those in this area, but this one's actually a lot wider. It's 36.5. So there's actually quite a bit of space to either put the units side by side or do something else with the plan and still accommodate the backyard condition. And just to be clear, when we look at these, if we see opportunities for a redesign, then that means there isn't a hardship. And I think that's the challenge here, that it could go up higher, or even just redesign it and do a more traditional kind of shotgun style. And you might actually be able to fit what you're trying to get in there. So I think the plan, having it being entering on the front and the back, it just doesn't feel like it was designed for such a small site. It feels like it was designed for another location and dropped here. So I'm having a hard time kind of vibing with this one.
Especially considering, I think within planning principles, I think some of which is spelled out within the CZO, we want to try to make sure that the primary entrances to these units do actually face the right of way, so that it's at least some assemblage of what's the appropriate scale and density of these residential structures can still be observed from the street. Otherwise, this is, I mean, again, it just seems a little regurgitated plan dropped and placed on this lot.
And just for reference, I know this area really well because I used to own a building just down the street. The HDLC boundary ends at the back of the property. So
it touches the bank.
The HDLC would not have appreciated this design.
Any other questions from the board? It's the pleasure of the board.
I'll make a motion. In regards to docket 2723, I move to accept the staff's recommendation for denial.
Second.
We have a motion and a second on the floor for BZA docket number 027-23. Accepting the staff's recommendation for the requested waiver. For Articles 11, Section 11.3.A1, Table 11, 2A for rear yard setback. And Article 22, Section 22.4A, Table 22.1 for off-street vehicle.
Actually, is it too late to call it back? I was wondering if we should defer it just in case. Because there may be a opportunity to do some redesign and still need a waiver for rear yard. So.
Or the parking.
Or parking, yeah. So
So
if
you
it's
want
a,
to rescind the motion?
yeah, I'm gonna rescind the motion if that's cool. And if y'all understand what I'm getting at, if we were to deny it, that means you got 2 years that you can't resubmit for the similar or the same,
For the same
for the same variance. So I'm gonna move to sorry, do I need or just make a
No,
new
go-
motion?
Proceed. You go
Okay,
ahead.
so make a new motion for 27-23. Move for a 60-day deferral to give them time to review the plans with staff and their professional record.
Second.
All right, so we have a substitute motion on the floor for BZA docket number 027-23 to defer this item for 60 days, giving the applicant time to look at a different design scenario. Please vote your screens. That motion passed. Next item. And just for clarity, if you guys deem that it's not necessary to come back in 60 days, you have the ability to withdraw that application. So just, if you coordinate with the staff, they'll be able to help give you next steps.
Okay, the next item is 2600 through 2602 Danielle Street. This request is for variances from the provisions of Article 11, Section 11.3.8.1, Table 11-2 of the Comprehensive Zoning Ordinance to permit the construction of a multifamily residence with insufficient lot depth and insufficient corner side yard setback. The subject lot is currently vacant. Properties located in the HU RM1 district are required to be developed on lots that provide a minimum of 90 feet in depth, and small multifamily developments, 3 to 4 units, are required to provide a corner side yard setback equal to 10% of the lot's width and no less than 3 feet. Based on this report, the staff believes that the requested variance of Article 11, Section 11.3.8.1, Table 11-2A, minimum lot depth, fails to meet criteria 6 and 7 of the standards of variance for Article 4, Section 4.6.f of the Comprehensive Zoning Ordinance, and that the property regulations will not result in a demonstrable hardship, and the change is exclusively for the convenience and profit of the owner. Additionally, the property in question provides 88.25 feet in depth, thus necessitating a waiver of 1.75 feet. The required corner side yard setback for this lot is 5.8 feet. The applicant is proposing to build a structure at the property line and therefore is requesting a waiver of 5.8 feet. Therefore, the staff believes that the requested variance the staff believes that the requested variance of Article 11, Section 11.3.8.1, Table 11-2A for corner side yard setback fails to meet criteria 1, 3, 6, and 7 of the standards of variance, in that there are no special circumstances which are peculiar to the land. The circumstances were caused by the applicant. The property regulations will not result in a demonstrable hardship, and the change is exclusively for the convenience and profit of the owner. Therefore, the staff also recommends denial of the requested variance for minimum lot depth and corner side yard setback.
Is the applicant present for BZA docket number 28-23?
Garcia Galvez on behalf of Zach Smith Consulting and Design, 530 South Norman C. Francis Parkway. Good afternoon, board members. I'd like to start off by discussing the variance for the corner yard setback. I apologize. Now, there is no question in the staff report. I do agree that it's not compliant and it doesn't meet the 9 criteria. But I do want to mention that more than half of the properties surveyed around the surrounding area aren't compliant as well. So it wouldn't be something relatively new to the neighborhood if granted. Now, I do agree with the side yard setback, everything said, but I want to discuss the variance for the lot depth. I don't agree that we don't meet number 6 and criteria number 7. Number 6, the hardship would be we're not allowing the property owner to build anything there, a multifamily home, which is what we're proposing in a multifamily district. So if the variance isn't granted, which is we need 90 feet, nothing will ever be able to be built there. And that's not number 7. It's not solely just for the benefit of them, the property owner, but for the city, because we want more housing. So although I can't really say much for the setback or the corner yard, I do want to see if we could discuss something about the lot depth.
Okay, that concludes your comments? Scott?
Yes.
Okay, thank you. Anyone else here to speak in support of BZA docket number 028-23? Anyone here to speak in opposition to this request? Seeing none, is there any questions from the board? Question to staff with regards exclusively to minimum lot depth. Are there any uses that would allow for a lot shorter than 60 feet within this district?
I don't know if we noted it, if I noted it completely in the staff report, but because it's in a historic district, single and two family developments would be allowed there. Although the requirement is for 90 feet, they would meet that non-conforming use exemption.
So with that level of consideration, that would actually help to close the gap with regards to criteria 6 and 7 for the lot depth.
If the applicant chose to develop a single or two family rather than a multifamily, is that what you're asking?
Gotcha. That's what I was trying to understand. If there was a different use other than what's proposed, that would fall within,
Only if it was single or two family. Only if it were single or two family.
it could be a lot that's less than 90.
Right.
Okay. Any other questions from the board?
Guess I'm just asking for it, maybe, I don't know. I'm being romantic here. I'm looking at the street view and the context of the neighborhood. And the code says that to determine the side yard, right? I guess the question is, what's determining the side yard requirement here exactly? Is it something about these required is 5.8, right? Not 10 or.
Oh, so, okay, I see what you're saying. It's based on the lot width.
Based on lot width,
Yeah.
not on the, okay.
It's a percentage of the lot width.
All right, yeah, because I'm just looking at the context and most of the buildings on the corner are actually 0 lot line. On the 4 corners around it. So I was just curious what, typically I'm thinking about front yard is based on the average of the buildings and whatnot, but it's just kind of a unique historic condition here. It's a shame the building was demolished that was on the site previously.
So just question back to staff. I'm going back and just checking what I'm seeing in the use table. I'm not seeing a separation of single multifamily versus single and two family for minimum lot depth.
So I surveyed a total of 25 blocks just to locate small multifamily units. So that's all you see in that table. are small multifamily units. It doesn't include single family, multifamily that are greater than 4 or 2 family.
Okay, so
And-
she's saying,
oh, I'm
go
sorry.
ahead. No, go ahead.
Just to clarify, the lot depth requirement in the HURM1 district is a flat 90 feet regardless of single family, two family, multifamily. The only difference with single and two family is there is an exemption in Article 25 that states if they have a deficient lot depth, they can still be constructed as single or two family.
Got it. Hence why the property behind it is a 30 or 31, I believe it is. It's a 31 by 50. So was that historically, that's an old re-subdivision?
When you say the property behind it, are you?
So I'm looking at property viewer in the corner of Donnell and Third. There's a lot that was behind it that shows historically, the historical address is 1926 and 1924 Third Street. That is insufficient, a sub-sufficient lot. It's 31 by 50. And that's, I guess that's one of those lots that it may have either been historically re-subdivided or just was that part of the historical context of that area. That
I'm not sure
causes
about
them
that
lot-
particular lot. Yeah, so I was just,
I'm
trying to
following
find
what you were
similarities
saying now.
between the
I was
properties.
asking it differently and
Okay.
Emily clarified what I was thinking.
Okay.
It is a flat standard, but you were saying that there's a separate article that provides a way to waive it. And in that case, the lot that's behind it, the 31 by 50 lot could be allowed as a single or double family, single or two family because of that other provision.
That's correct.
Any other questions from the board? The motion's in order.
Just had a question for the applicant as it relates to, hi. So you were saying that, out of the two requests for waivers, the one with the corner side yard, you would have been able to deal with that through design? You would have redesigned the building to accommodate that 5-foot setback?
Yes, sir. We advised our client that that was an option, but they wanted to proceed with trying to get the variance.
Because I do agree with you, Rami, that that corner, all buildings are against the property line, and it's the right contextual thing for a corner of such, compared to like, others that will be an odd condition to create a 5-foot setback on a long building, creating effectively kind of like a weird side yard where all those buildings are effectively in the corner. So I think that is a good point historically as to how the building should be footprint on the site.
What's the pleasure of the board?
Just trying to think how to say this. Does the letter? I'm trying to go back and look at what you guys put in the letter. Does it address the historic nonconformity there, or the historic precedent?
It sounds like the historic precedent was provided by staff, but on single and two family.
I meant for the lot line, the corner side,
Lot line,
corner yard,
yeah.
the back.
Did you ask me a question? Or were
No,
you-
I was asking the
It was more about the applicant's
Applicant.
letter. The 9-point criteria response.
yeah.
I'm sorry, sir. I don't believe we included it, no.
I was trying to be lazy and just use your letter. So in regards to docket 28, 23, before I do this, but do we have provisos if we,
Just be the 3 standard for this.
okay,
I would also add a fourth to comply with the exterior lighting requirement.
all right, so in regards to 28, 23, I move to approve both waivers with the noted provisos, the standard provisos, including the lighting one, which I don't know how to word. Sorry. Citing that the 9 criteria have been met, specifically with the corner side yard setback, given the historic nature of the corner as a commercial kind of corner there with zero setbacks on the 4 other corners. I see that there's a historic precedent there, unique to this site. And then the historic nature of the site itself being smaller than 90 feet would meet the, sorry, I forgot the minimum lot depth. Yeah.
Second.
Okay, we have a motion and a second on the floor for BZA docket number 028-23. Accepting, not accepting the staff's report, excuse me, to grant the waiver for the requested waivers of Article 11, Section 11.3A1, Table 11.2A for minimum lot depth, and Article 11, Section 11.3A1, Table 11.2A for corner side yard setback, and stating that the 9 criteria have been met by way of the letter provided by the applicant and by the additional commentary provided by Commissioner Diaz. And the 4 provisos is the 3 standard and the 4th is provided by staff. Vote your screens. All right, that motion is passed. Next item.
Thank you. I'll be back in 2 minutes.
We will now begin with new business for the Director of the Department of Safety and Permits Decision Appeals. We did get a request that from the applicant to suspend the rules to accept affidavits that were received after the deadline. And this is for, I believe, affidavits for the residents that are nearby, right? Neighbors. I saw that something in the email. Didn't. My computer died, so I can't.
1 moment.
Okay, Bob.
Yes, these were affidavits from the neighbors.
Would anyone like to introduce a motion to accept those affidavits?
So moved.
Second.
All right, we have a motion and a second on the floor to accept information after deadline affidavits provided by neighbor and property owners. Please vote your screen. So what I'll do, we'll just do the, all right, there you go. Never mind. Go ahead and vote your screens. All right, that motion is passed. Go ahead and forward that.
Thank you. I forwarded that to your emails.
Thank you. Kendall?
Good afternoon, everyone. Once again, my name is Nick Kendall. I'm the zoning administrator in the Department of Safety and Permits. BZA docket 2923. Relative to 1530 Hillary Street, the applicant's appeal alleges an error in the decision of the Director of the Department of Safety and Permits regarding the issuance of permit number 22-36284 RNVN, allowing for the renovation of a two-family residence with alleged insufficient off-street parking spaces in accordance with the University Area Off-Street Parking Interim Zoning District in a parking pad with insufficient width. The subject property, 1530 Hillary Street, is a two-family dwelling that is being renovated. On December 5th, 2022, the architect applied for a building permit to renovate the structure, and the permit was issued on January 19th, 2023. The subject property is located both in the University Area Off-Street Parking Overlay District, the overlay, and the University Area Off-Street Parking Interim Zoning District, the IZD. The IZD went into effect when City Council adopted motion M22449 on October 6, 2022. So the permit is subject to the IZD since it was in effect when a complete permit application was submitted. This building permit was reviewed under the IZD requirements, which requires one off-street parking space for each new bedroom created. For the downstairs apartment, it has 2 existing bedrooms and will have 2 bedrooms after the renovation. For the upstairs apartment, it currently has 2 bedrooms, but it will have 4 bedrooms after the renovation. This will require 2 off-street parking spaces for the 2 additional bedrooms in the upstairs apartment. The appellant raised a couple of potential issues with the approved permit, which are addressed below. 1. The new upstairs dwelling unit lacks a living room and consists only of 4 bedrooms, 2 bathrooms, and a kitchen. The appellant states that city code requires that a dwelling unit or that dwelling units that are not in efficiency must have a living room. The comprehensive zoning ordinance does not have any requirement that a dwelling unit must provide a living room. Zoning appeals to the Board of Zoning Adjustments are limited to decision of the Director of the Department of Safety and Permits on permits issued under the comprehensive zoning ordinance. This is not a CZO requirement, therefore it is not appealable to the Board of Zoning Adjustments. Furthermore, the city code sections that were cited were in the minimum property maintenance code that is enforced by the Department of Code Enforcement and not the Department of Safety and Permits. 2. This dormitory project has a deficiency of 2 required parking spaces under the 2022 University Area Off-Street Parking IZD. Due to the increase in 2 bedrooms in the upstairs apartment, 2 additional off-street parking spaces are required for those 2 additional bedrooms. In general, a dwelling unit is required to provide 1 off-street parking space, so the upstairs unit is required to provide a total of 3 parking spaces. On the Jeanette Street side of the property, 4 off-street parking spaces are provided, which meets this requirement. While the driveway does not meet the minimum required width, that deficiency is grandfathered in. As for the downstairs dwelling unit, there is no increase in the number of bedrooms, so there is no requirement for additional off-street parking spaces. The downstairs dwelling unit is also required to provide an off-street parking space. While there is an existing parking street on the Birch Street side of the property, it is shared with the adjacent property. It is unclear if this is a legal off-street parking space or not. If it is a legal parking space, then the required parking space has been provided. If it's not a legal parking space, then the lack of a parking space would be a grandfather. Since there is not any changes to the downstairs unit that would require additional parking spaces, it's not required to determine if this is a legal parking space or not. The Department believes that the building permit was approved in accordance with the comprehensive zoning ordinance, and for the reasons stated in this report, the department's decision should be upheld. And that concludes my presentation. Thanks.
Thank you. Is the appellant present for BZA docket number 029-23?
Good afternoon, staff. My name is Melinda Alfonso, and I live at 1535 Hillary Street. This home has been in my family as long as I can remember, and my grandmother wanted it to stay that way. 25 years ago, when grandmother Alfonso was 90, she invited me over for dinner. She knew that living alone was no longer an option and wanted me to have her home, a place I could call my home in a neighborhood that she had lived so long. Across the street was the Navarre family at 1526-28 Hillary Street, and knew my grandmother very well and would share stories with me. Being a single woman, it gave me such comfort to know I had friends on my block to help me get ready for hurricanes, someone I could call in case of an emergency, and help watch my home when I went on vacation. When the Navarres passed away, their shotgun home went on the market January 15th, 2022. It sold to Barry Silva, a developer that added more bedrooms, just as a developer will do. The smaller 2-bedroom is currently advertising on Zillow for $2,400 a month. 1 month later, 36 Hillary Street went on the market. I felt a sigh of relief to learn that the owner gave the current long-term tenant, who was a professor at Loyola, the first right of refusal. The professor, as we called him, put in his offer at the appraised asking price of $429,000. He also promised to let David, the other long-term tenant, continue to live there when he became the owner. 2 days later, while I was having an afternoon glass of wine on my porch, the professor, as we called him again, came over holding back tears to let me know that developer Preston Tedesco put in an offer at $61,000 over appraised value, and his bank would not loan him the money. After Tedesco took possession, both the professor and David quickly received letters in the mail that they had a few months to find other places to live, so he could start renovations of a Camelback and, of course, add more bedrooms. Sandwiched between these two recent developer acquisitions were retirees Clay and Melissa Smith. Clay became as scared as I was about our block, and when he saw that safety and permits kept siding with the developers, he decided to sell and get out. Unfortunately, Clay sold to developer Barry Silva, and thus here we are today. I officially now have 5 dorms to doubles on my block, and there are 3 of us homeowners left. 1 soon to sell, get out as well, and move to Old Metairie. In 2022, I officially joined forces with the Stop Doubles to Dorms team to try and save my block. It took me quite a few months to educate myself on what a CZO was, how it works, who implements it, and so on. I contacted everyone I can, anyone that would listen, and even took my concerns to the state level. Senator Amy Freeman helped corral a neighborhood meeting with the state fire marshal, and the turnout was simply exceptional. So many of us just begging for help. Councilman Giarrusso and his staff diligently worked on revising the IZD, which went into effect on October 6th of 2022, because the overlay was not protecting us. Item number 22.8.A.1, item C reads, tandem vehicle parking is permitted for residential uses but both spaces shall be allotted to the same dwelling unit and located on the same lot as the dwelling unit. Hey Siri, what is the definition of both? Both used to refer to two people or things. Hey Google, what is the correct definition of both? Adjective, one, the other, two together. Here are my questions for safety and permits. Regarding the tandem parking, item 22.8.A.1, the word both, while we interpret this to mean two, your staff is allowing for 4 cars to be stacked in a tandem line. Can you explain this? Number 2, why is this property being grandfathered in for parking? Can you refer me to the section or sections that allow for grandfathering no matter what the CZO says? Number 3, moving forward, will every home with no parking be grandfathered in by safety and permits and exempt from the IZD and what the overlay rules say? And again, can you direct me to the languaging where this property for the grandfathering applied?
If you could bring your comments to conclusion.
Yeah, somebody, Deborah Cuny allotted me her time. I believe you have a card for that.
Yeah, but I need to be made aware of it.
Sorry.
3 additional minutes.
Okay. Just like the Airbnbs were destroying the Bywater, Marigny, and Garden District neighborhoods, the residents and city council pulled together to enforce stronger regulations. All we are begging for is some attention, some support, and respect with the dorm to doubles to dorm conversions. I am beyond fed up because no matter what we do, you guys keep approving everything and every dormitory permit, and the BZA denies each appeal. Did you know that we currently have approximately 105 such homes in our neighborhood? The rents are not affordable. They are making our local people homeless. Knowing what I know now and that the developers have the upper hand, I'm strongly considering turning my own double into such a dorm. 8 to 10 bedrooms are going for $1,500 per bedroom. That is a monthly revenue of $15,000 per month and $180,000 annually. As I say, if you can't beat them, you might as well join them. On a final note, the majority of these developers are not from New Orleans, nor were they raised in these neighborhoods, and simply do not care about what's going on. Thank you for your time.
Anyone else here in support of this appeal?
Hello. Good afternoon. My name is Deborah Howell. My address is 1540 Adams Street, and I appear here today as both a concerned Carrollton neighbor and as a representative of the Central Carrollton Neighborhood Association, within whose boundaries 1530-32 Hillary is located. By my count, the BZA Appeal Summary Report for 1530-32 Hillary contains 3 new interpretations of language in our zoning code by safety and permits. First, the most heartbreaking one, and breathtaking one, is safety and permits claim that they are not responsible for the substandard dwelling unit that will result from their issuance of this building permit to the developer. It's code enforcement who is responsible. Even though it was their permit that allowed the conversion of a standard legal dwelling unit into a substandard one, that lacked the required living room and dining room for a unit with 3 to 5 occupants per section 26 of the city code. But somehow safety and permits has decided this violation is not their fault and not their violation. This denial of responsibility claim by safety and permits is almost as absurd as their previous claim that open porches and stairwells should count as existing bedrooms. And the idea that code enforcement must now get involved in new construction and renovation permits because of bad permitting practices and decisions by safety and permits simply boggles the mind. Then there's the language on tandem parking and driveways, which reads, tandem vehicle parking is permitted for residential uses, but both spaces shall be allotted to the same dwelling unit and located on the same lot as the dwelling. The use of the word both, as Ms. Alfonso has said, as a modifier for tandem would mean only one thing, which is two. Nor is there any ambiguity inherent in the word both, since every single definition of the word says it means two or two together. But not to the Department of Safety and Permits, which has issued many dormitory permits over the past 3 years, in which both, when applied to tandem parking, is interpreted by them as an infinite number. Many of those permits were appealed, so both safety and permits and the BZA got to fully participate in this farce in which both no longer meant two, at least when it comes to dormitory permits. Third, since when does doubling the allowed number of tandem parking spaces from 2 to 4 in a 7-foot wide non-conforming driveway qualify as an exception to the regulation that non-conforming uses shall be prohibited from expansion or an increase in area without a variance? Even if it did qualify, it is still in violation of Section 3 of the IZD, which states that its increased parking requirements shall not be waivable and exceptions in the CZO shall not be applicable or available if the dwelling unit is being substantially renovated, which includes the erection of walls to create a new bedroom. Making exceptions to both common sense and common word usage in the CZO, especially when it involves the absurdity and physical impossibility of 4 cars parked in tandem in a 7-foot wide driveway, is directly in opposition to the intent and purpose of the University Area Off-Street Parking IZD. The IZD also does not provide exceptions from its parking requirements for properties that have non-conforming driveways and parking that cannot be expanded. It does provide that the developers are free to make an appeal to the council if they disagree or apply for a zoning variance. Therefore, the BZA should uphold the appeal of Ms. Alfonso. Thank you.
Thank you. Anyone else here to speak in opposition?
Hi, Susan Johnson, 2822 LePage Street. I am not paid to be here. Native of Carrollton. Grew up there, and I've been tracking the private dormitory commercial development in the neighborhood since 2019. It doesn't stop. In 2020, I counted 40 houses in December 2020. Now 113 is the number I have right now. And my organization, townofcarrolltonwatch.org, lots of statistics on purchases and permits. Dove Silver and his associate Shay Schneider and Sholem Eckhouse entered the New Orleans real estate market in early 2021. Their beginnings are documented by City Business article of December 2nd, 2021. Childhood friends from Brooklyn investing in New Orleans. They started out in Baton Rouge with 2 developments and now have 11 or 12 in New Orleans. 3 of these properties are private dorms. 2 were cited for working without a permit. Not this one though. 7620 Zimple and 1528 Hillary were cited in May of 2022. But this property, as I said, has not been cited for working without a permit. You've said, the BZA has said that they can't discriminate against so-called bad actor developers. I feel that I can discriminate against bad actor developers because I don't know what else to do about the situation. It doesn't stop. We've got legislation coming up this Thursday, the reenactment of the amended IZD. Loopholes are continually found. Another vote sponsored by Geruso and Harris this Thursday. In the meantime, we register our complaints in the public record. Complaints to safety and permits, which is now being overhauled by Tom Mulligan, complaints to city council, complaints to the media. I complained to city business about the lack of, about working without a permit, and they pulled this article lionizing the developers from their server to their credit. And most particularly, complaints to the fire marshal via Amy Freeman's office about the possibility of overcrowding in these developments as evidenced especially by this application, the lack of living space.
If you could bring your comments to a close.
Thank you. Prescribed by the city code. We are following the activities of these developers and updating the above agencies at the city and state levels. We are not stopping. Thank you.
Anyone else here to speak in support of this appeal? And ma'am, didn't you defer your time?
I was gonna say, did I have any time left or did?
Once we defer it,
Oh, it all goes. Okay, well, thank you.
thank you. Anyone else here to speak in support of this request? Anyone here to speak in opposition to this appeal?
It is opposition, huh? Not just info. Okay. Garcia Galvez on behalf of Zach Smith Consulting and Design, 530 South Norman C. Francis Parkway. I want to thank Safety and Permits for upholding its original decision of issuing out the permit. And the fact is, folks, the proof is in the pudding. We could all see that the parking is valid, has been valid, is transparent, and thank you very much.
Anyone else here to speak in opposition to the appeal? The appellant has time to rebut.
Yes, I'm not sure how this works, but are my items regarding the parking, the three questions we had, going to be answered at this time?
Ask that question again.
In my previous, I had some questions for safety and permits.
So right now, this is your opportunity to rebut anyone who spoke in opposition to your appeal and rebut any facts provided at that time. If there's any questions and answers, I mean, you could bring them up, but they're not going to answer you at this time.
Okay. Regarding the tandem parking and shared driveways, this is very common in the Carrollton neighborhood. The neighborhood was developed with the shared driveway concept. I have one myself, and it is virtually impossible with the unit next to me to put 4 vehicles in a shared driveway. I really feel that in order to eventually clear this up regarding these shared driveways, I think it would be a good idea for safety and permits, the councilman, Senator Freeman also suggested this, that we come out and watch how I have to maneuver vehicles in a shared driveway. The reason we got the fire marshal involved regarding this tandem parking is because when you stack a vehicle shared 4 on both sides, it does not allow, in case of a fire, it does not allow exit from the rear of the building to go down a driveway unless you jump over vehicles. And then lastly, stacking the vehicles in a driveway, which is going on now, there's nowhere to put the trash cans. They can't fit in the driveway. The passenger in a vehicle cannot get out because your door hits the side of the house. So that they're not going to stack 4 vehicles. We all know that, but I know there's nothing you can do about it. I just really feel like this is an issue that it eventually is going to become a safety fire issue when they cannot exit their homes, these apartments properly. Thank you.
Any questions from the board? Just question to Mr. Kendall. With regards to stacking, when there's a reference made of both versus multiple vehicles, is there a limitation within a CZO that limits the number of vehicles that are supposed to be queued within stacking?
There is not. In the definitions, it gets to referring to things as singular in the plural, plural in the singular. It says both. This issue's come up before, even including to this board, and safety and permits has made the determination, which has been upheld by this board, that you can stack more than 2 vehicles.
Correct. And if I understood correctly, when there's a reference of both, it's always been, because I think in most residential uses, we'll see that there's a limit, that you may say 1 or 2 required parking, off-street parking.
Yeah, and most dwelling units require 1 per space, and you can only have tandem within the same dwelling unit. So
You
it's
gotta be
not
within the same
something that we look at very often, except in this area where you do end up having, because the additional bedrooms trigger additional parking, that we do kind of see this tandem issue. I think this could be something that's right for a text amendment to clarify, if that's something that, the residents want to make sure it's limited to 2, that could be put in the CZO and say, tandem parking limited to 2 vehicular spaces, and that would then be the way we interpret it. But under the current language, we're interpreting that tandem can be more than 2 spaces.
And if, just as a point of clarity, when the comments were made about accessibility through the driveway, that's almost an appeal of the design standards for site design standards, especially for how you would configure parking. I think right now you're allowed to have the site development requirements spell out a certain distance from the property line before a parking stall can start, and then the general width of that required parking stall. I mean, the reason why I'm making that comment is the public comment spoke to safety of ingress egress from the rear of the property. That seems to be almost be the standard across the entire city, whether it's dorm or 2-family or multifamily with driveway standards. There's nothing that spells out that you need additional space for someone to bypass a vehicle for ingress or egress, correct?
Correct. There's nothing in the zoning ordinance that gets that specific regarding egress, and that's more life safety issue that is more appropriate for state fire marshal or in the building code. So and I honestly can't speak to those requirements because that is way outside my knowledge
Wasn't going to
area.
expect, and that's why I brought up specifically the site design requirements within the CZO, and because it's not spelled out there, there's nothing to really address.
Yeah, and I will say the CZO does require, has minimum standard for what a driveway would be, as well as, there is a requirement that there's a 1-foot setback from the driveway to the property line. In this case, obviously, those requirements are not being met. We've determined that this is a grandfathered condition on this property because it's, an existing driveway, an existing parking strip. So we've determined that it's grandfathered in.
Thank you. Any other questions from the board? It's a pleasure to board. Any further questions?
Yeah, I'm a little confused about the shared parking condition again, I mean, you just went through it, but still the property that's to the north, and how does that, given that it's going over the property line, is there some sort of commonality situation, or how does that get described in a? I'm just a little confused by that, because if the parking went away, let's just say that it wasn't there. In the future, I mean, it's just the fact there's the strips and there's a history of parking there, right? And neither of those parking spaces are compliant for either property, right? So are they both sharing the property line overlap?
And this is on the Birch Street side?
Yeah, the cemetery side.
Sorry, I'm not quite familiar with the cardinal directions with regards to this particular. site,
Exactly,
but,
yeah, the Claiborne side, yeah.
Okay, so yeah, typically with new shared driveway situations, we will see some sort of easement between both properties that give, both properties the ability to use that shared driveway, and typically it'll lead to a legal parking space, on either of the property, so it won't be a parking space that's kind of split between the two lots. In this case, it's an existing situation, so this isn't a new driveway. I honestly have no idea whether this is like a legal configuration or a legal parking spot, but to the extent that this shared driveway isn't required to provide any additional parking due to this renovation, therefore, it's kind of a moot point from our standpoint, because we aren't having to confirm that this is a legal parking, because they're going to be adding additional parking spaces there. The additional parking spaces are going on the Jeanette Street side, and so like I said, it's not fully compliant with the CZO because it's maybe, I think it's supposed to be 8.5 feet wide and it's only 8 feet, and doesn't have the 1 foot setback to the driveway requirement. So there are a couple of deficiencies on that side, but all the parking is located on the particular lot.
I guess the only part that just reads different is that it almost appears that the wheel strip runs into the front edge of the building as opposed to going beyond the front edge of beyond the property. But even if in that case, if it was to be documented otherwise, there's record of 4 wheel strips that go back to the rear of the property. So while it may be showing that it's encroaching on the house to, I guess that's the 1534 Hillary property, it still shows 2 neighboring driveways. And what we've dealt with in the past is that it's either a shared easement for that driveway. Any other questions from the board? What's the pleasure of the board?
Motion's in order.
You proceed.
Regarding docket number BZA 029-23. I move to deny the appeal. Try this again. Regarding docket number BZA 029-23, I move to deny the appeal and uphold the decision of the Director of Safety and Permits, finding that there was not an error in the interpretation of the comprehensive zoning ordinance.
We have a motion on the floor. Do we have a second?
Second.
We have a motion and a second on the floor with regards to BZA docket number 029-23, upholding the decision of the Director of Safety and Permits, finding that no error was found or presented in this case. Please vote your screens. That motion passed. Next item.
Motion to adjourn?
So moved.
Second.
We have a motion and a second to adjourn the meeting. All those in favor? Aye. Aye, aye.
All right.
Thank you. Meeting's adjourned. Thank you.
Hate this shit. I like this part thing. Like. Absolutely, dude. It's like an abuse of like everything. And like, it's just like, there's nothing to do about it. Oh, it could be a dump. Yeah, look at this. Yeah, I agree. Yeah. No, it's like obvious. It's just the problem is like, there's really nothing you can do there.
And it's just like, they could just make it an apartment. Like, the fact that they're counting rooms that they're otherwise.
Correct. I was looking at the David, or basically that people was, saying that they had parked in that area. And
That's
like-
why I was asking the question, because I was like, then I was getting. I'll bring it up. What's gonna happen?
Yeah. But the one on the right side is not. A portion.
Oh, yeah. Sure. Yeah. There's gotta be something.
Well, the whole thing about that group is but this issue of having like parking.
It's just like. I can't regulate. It's just some other thing.
Oh, okay. Okay, we got all that news fixed. All right, thank you, Terry.
Deal with these kind of situations very episodic, we have certain people who all do provide parking, and the stuff that can provide parking, and sort of the offering of. And I'm not aware that. Yeah, yeah, if you open not before you set that line, you extend the not before you set that line. Yeah, if the house is already, put in half of the property line, you can do in addition to, as long as they're getting closer than you put half, you can do it to maintain. That's what the zoning will say to that. And I can speak to that, I mean, if it's on his side of the property, I was gonna leave it to his side. So if it's something that's just a fun building environment where you get into required or anything like that, consider maybe there's, there's notice coming, which is something you can sign up for, it'll notify you if any permits are issued. So you get an email notice of that, and you can set it up to, something that's comfortable, sticking with code if you need it, but I think you can kind of raw your own map, and you can say what you, what you want, if it's, any decision going for the board, then you adjustment for it, can be permanent. So I don't know the exact website, but noticing is what it's called, but it's noticing, search noticing the water ones that come up, and so that way you get notice of any building permit that's issued within whatever area. So yeah, I mean, it could be anything from building a pool or, in the back room to, they're doing new construction. Okay, you're welcome.
How y'all doing?